I think everybody's well aware what we're doing, and it's on the record from yesterday. So we will proceed straight away with you, Mr. Montague Smith.
Thank you, Your Honour. All right, so there are 9 points raised in this application on the application notice. As we understand it, one of those points has been dropped. That is the licensing point, albeit my learned friend maintains the factual allegation that my client was operating without a license, so he doesn't feel able to drop that. That is false, and there's no evidence to support it. And I'll have to deal with that as well, unfortunately. Many of the other points have changed substantially, and there are new points lobbed in along the way. So you have your entire agreement clause arguments, for example, which, had they been raised earlier, would have been met with authority, which demonstrates that they are just hopeless. But I will try to pick up the points that have been made along the way in the course of yesterday. But first, with Your Honour's permission, what I was going to do was just set out a little bit about the claim itself. Now, I'm well aware that Your Honour has quite a lot of the facts, but if you'll indulge me a little bit, I'll just take you through what we say about the claim, and I'll try to move quickly through that. But it's important to set the scene a little bit, if that's all right. So Your Honour knows that the contract itself, so the partnership agreement, as it's called, was entered into in June 2020. It's in the bundle at page 37, but I think you've got it separately. And I just wanted to show you a few features of that we rely on. Just starting though with the language, the partnership and services agreement. Now, we of course accept that it didn't give rise to a partnership in the legal sense understood in DIFC law, but the way in which the parties describe themselves and this agreement, we say, is somewhat significant, because taking a step back, in his submissions, my learned friend repeatedly invoked the commercial context when explaining what he said about the meaning of the contract. So he said it would be commercially unreal for his client to sign up to certain things. And the context is, we say, quite important in interpreting this particular contract, because something has gone wrong in the drafting of it, and I'll show you why we say that. And even on my learned friend's case, we say that must be right. But we don't accept this characterization that the claimant was simply a service provider hired to provide technical services, because what we say is that this agreement was in substance, a form of merging, or a means of merging, the two businesses together. So prior to this, the two parties were each really the two biggest luxury real estate agents in the market, and the result of the deal was that they would combine their businesses in accordance with the terms of the agreement. And now, I think you're aware, we'll come on to it, the parties had contemplated a straightforward sale of the business, and so they looked at they'd agreed in principle a price which was 12 million dirhams, and that was then reduced to 5 million dirhams plus this, what's been described as this partnership fee. And as we will see, this was intended to act as a form of royalty. So it wasn't simply saying, this is the value of these services, we're going to pay you for these. It was another way in which the claimant was being compensated for giving up the business that it had. So if you look at page, well, it's clause 4.1 of the contract, but it's page 43 of the bundle, you see there at 4.1, that's the consideration of 5 million that's been agreed, and that's to be paid in staged payments, and the staging is important. We'll come back to it later. That's over the page at 4.1c. But then at clause 5.1, that is the marketing and branding partnerships. This is page 45. And subclause A explains a little bit about what that involved. So the seller will lead and support the buyer in digital marketing with a focus on website traffic and lead generation. And B, that includes, the scope of the work includes website maintenance and improvement, but also SEO, content strategy and generation, social media strategy and implementation, property alerts strategy and implementation, newsletter strategy, public relations strategy, and implementation to increase media mentions, both in print and online media, and also support on property portal strategy, including budget optimization. And when you look at those functions, we say that is a really important, indeed central part of a modern real estate brokerage business. And in submissions yesterday, Your Honour ventured a summary of the role as being the people who were left behind were the techies. But we say, and we understand why you take that view, given the submissions that were being made, but actually we say digital marketing is much more than that. It's not just about operating the technical aspects of a website, for example. It is a
Mr. Montague Smith, be reassured, I'm under no illusions about the importance of tech in marketing and advertising. I've been involved in many cases, and my observation was conditioned by the submissions I was hearing at that moment.
Of course, and I'm not intending to suggest that you've drawn any conclusions on these issues at all. What I'm trying to do is just counter a little bit that the way in which the setting, perhaps I can put it, in which this contract has been explained to Your Honour, and just explain that, and you may have this already. Some judges do, some judges don't, and I make no assumptions about that, but I'm sure your experience. I make no submissions on Your Excellency's experience on this. All I'm doing is just explaining the case that we say it is a primary sales function. It is the primary sales function, we say, for the business, and so that you just going through the contract then on page 45. So at C, we know the partnership was to last for 10 years, so that's to June 2030, which was subject to D, which had two conditions. Partly it was KPIs, so key performance indicators. That's little Roman numeral 1, yes. And partly it's about the management. It is not alleged that those circumstances arose. And then over the page on 46, we've got the bits about branding. So firstly, F gave the defendant the right to use the brand and the domain name, and G set out the process for developing a co-branding strategy. And in the end, as a matter of fact, that co-branding strategy was agreed. So it said during the term of the partnership, the buyer and seller have agreed to implement a co-branding strategy to combine the market strength of both companies and increase brand awareness. And then you see the second half of that clause. The parties agreed to conduct an external study to determine the way to do that. And then the final sentence, both parties have also agreed that the new branding will be implemented not later than 3 months after the closing date. And that was obviously the focus of the interim application. I'll come back to that in a moment. But then H and I, we get to the fees part. And obviously for the first year that's set as 2 million, and then you've got this, and this obviously changes, and I'll show you that, but you've got after the first year 2 million dirhams uprated for inflation, or the 5% of the combined gross revenue of the previous calendar year, whichever is the greater. So, and the clause makes clear over the page, you can see if the combined gross revenue exceeded 40 million dirhams, then the fee would be 5%. So that's just to clear away that it's the highest of the two choices, because 5% of 40 obviously is 2 million. Now, as you've seen, those provisions were subsequently amended by the addendum, and that is at page 70 of the bundle. I'll just look at that now, if that's all right. And you've got paragraph 1, which increases the minimum fee for the first year of the addendum. So 1st of September 2021 to 31st August 2022. So it's the highest of 3 million or 5%. And then paragraph 2 after that, the higher of 2.4 million or 6%. So the estimate is lowered, but the reward, if I can put it that way, is increased. Paragraph 3, there is provision that if it's not working out, the parties will meet and discuss, but the final sentence unless there is a new agreement between both parties. The partnership fees described above in point 2 would apply. Now, yesterday, my learned friend took you to paragraph 4 of this, and he said, well, actually, the effect of paragraph 4 was to fix the fees that were due. That's a new argument, and it is, we say, clearly wrong, because clause 4 is clearly only about advance payment of the minimum fee. So the point is, you cannot pay the variable part in advance because you don't know what it is. So that obviously comes later. Now, if my learned friend's submission was correct, it would apply to all of the fees for the whole of the contract, because you see, it doesn't just apply, looking at the second line, second sentence, from the 1st of September to the 31st of August 2022. It goes on after the setting the sum. It says, and from the 1st of September 2022, the monthly payment will be 200,000 unless agreed otherwise. So it applies for the whole of the contract. So the effect of the submission is to cut across any variable fee whatsoever, which would fly in the face of clause 1, clause 2, and clause 3, and the scheme of the contract as a whole. So we say it's quite clear that the parties were agreeing to keep a variable fee. They were just adjusting it, and the contract makes that very clear. Now, we know, if we go back to the original contract, this time page 60, it's schedule 3 of that. So it's page 22 internal of the contract. We know that the defendant was obliged to provide financial reporting information. And so you see that clause 3.3.
Yes.
And I think you've read these, but it requires revenue statements during the first 5 days of every month for the previous month, and includes certain data, and also, final sentence, quarterly on an annual basis, a consolidated revenue statement and profit and loss. And then 3 point.
Sorry, Mr. Montague-Smith.
Yes.
To refer back to another question of mine yesterday, it would have been apparent I wasn't entirely clear, and I'd like your version of how this actually worked. And this is what you're doing now, I think. But so it's under this clause where I was asking questions about periodic. You recall those questions about periodic statements? This is where it comes from.
Yes.
Right. So
yes,
sorry,
that's my case.
I interrupted your thread. Please.
No, and I was going to show you. I was going to show you exactly what we say about this, because I think my learned friend's submissions, I didn't quite understand what he was saying about this, because you asked the question, is this spreadsheet, and we'll look at it, was this the one that was provided by the defendant pursuant to the contract? And I thought he said no, whereas his evidence actually says yes, but I don't know where we got to on that, and it may be that he accepts that it is his client's spreadsheet. I think what he was saying ultimately was we just provide the spreadsheet, and then it was for the claimant to take from that the numbers. That still doesn't explain why we say there's all these missing sales from the spreadsheet. But anyway, we'll get on to that. So 3.3 is requiring this monthly provision of financial data, but also quarterly and annual accounts. 3.4 makes clear that the buyer is to provide the seller with audited accounts, and it's never done that. And then 3.5, in line with clause 9.2 of the agreement above, the seller should have access to the buyer's financial accounts whenever any clarifications are needed. And if required, the seller can even do its own due diligence in this regard. So this is obviously, I'll come on to develop my response to the 9 points, or 8 points as they now are. But ultimately, this cuts across 2 points. One is, we say, and I'll get to it, ultimately it's quite clear that the reason for these provisions is because it was allowing the claimant to track the buyer's performance. So it's allowing the claimant to track the defendant's performance. And that only makes sense through the whole of the contract. And that only makes sense if the partnership fee is calculated by reference to the defendant's revenues. My learned friend's response to you yesterday on this, well, what's the point of these provisions, was, well, it allows them to track it for the purposes of the payment of the lump sum, because obviously that's payable down under a note. But that lump sum was payable out in 3 years. And this is a provision which applies to the whole extent, the whole period of the contract. I'll come back to that. So what happens is that every month, the defendant did send a Google spreadsheet to the claimant. And you see the consolidated version of that at 1118, the bundle. Yes. And that is an updated version, which appears to go through all the way down to 2023. So I believe that incorporates all of the data that was provided down to page 1145. Now, as I say, it's not clear whether it's accepted that this is a spreadsheet which comes from or derives from the defendant. If that is disputed, that's simply a factual dispute, because my client's evidence is that that is where it came from. You can see that in his witness statement at page 1062. And I'm sure Your Honour has done a lot of reading, it sounds like, but you may have read these passages carefully, I'm sure.
I've read the witness statements, but obviously I will be assisted by focus on any particular paragraph that either of you wish to refer to. So don't hesitate to take me to a particular paragraph. It will be of assistance to me from both sides.
Thank you very much. So we're on page 1062. We're in Mr. Fontmante's witness statement, and I was going to show you paragraphs 39 through to 43, actually. But essentially here he's making the point that when the parties dealt with each other post-contractually, he says that the payment that was made by the defendant for the first period was only consistent with his interpretation, or the claimant's interpretation of the contract, because they paid a variable fee over and above. But in the course of this evidence, he's making that point. He's explaining the source of this data as well, and then he says, paragraph 40, the reports extracted from the defendant's reporting shared with the claimant every month demonstrate the combined gross revenue for the period. And he goes through it all, and then he says, paragraph 41, that revenue was used to calculate the partnership fees, and then the third line down, the partnership fee was then duly paid. That was a question you asked my learned friend, was it paid?
Yes.
There's evidence that it was. Now he may, or he doesn't. I mean, he was fairly non-committal in his response to that, but obviously you're operating on the basis of whether of the evidence that will come before trial without deciding the facts. So there is evidence that it was paid. There's a real prospect of showing that it was paid. And over the page 1064 on paragraph, yes.
Sorry, just before you move on. So I probably garbled my question. Apologies to you all for that. But essentially, what I was trying to ascertain was, if the combined gross revenue, as you claim it to be, and as you say it was reported in the spreadsheet, is the figure that you say was paid the relevant percentage, 5% I think it was, of the revenue as revealed in the spreadsheet at the date of the invoice and payment?
It's 5% of the revenue over the minimum threshold. Yes.
Sorry.
Because they paid in advance the contributions to the minimum threshold. They've calculated the amount over that threshold, and then they've applied the 5%. So that's what's happened, and that's what Mr. Fontmante is seeking to explain there. And then he says it was paid. So that's consistent, as we say, with our position that everybody knew that what we were looking at was the defendant's gross revenue. But we'll come back to that. You've got the invoice, and we can see it there perhaps best at 1146.
Yes.
So you'll see this is September, in the middle of the page, 30th of September 2021, and you see under the description 5% over target marketing fee, and then the amount is listed at 7338001. So that's what that's saying is you've got the 40, which has already been paid in advance. You've got the amount over that, 7338001. So what we need is 5% of the amount over, which is the 366,900. And that is the amount that was then invoiced.
It doesn't actually show the total gross revenue, does it? This invoice?
No, but we say you can extract that.
Yes, you can work it back, can't you?
You can simply extract it from. That's what Mr. Fontmanti says. You can add it up. The figures are there. Nobody suggested that if you do it differently, it doesn't get you there. That's just what it is. Now, in relation to this, what's the response to this on the evidence from the defendant? Well, you were taken to page 1612, which I think is Mr. Texera's statement, and you were asked to read paragraphs 33 to 34 in relation to this. Now, the first point is you can see 1, 2, 3, 4, 5, 6 lines down. Yes. He refers to the reports, and he says, in fact, these reports, i.e. the Google spreadsheets, which Mr. Manti refers to at footnote 1 of his witness statement, and then he says, which were shared by the defendant with the claimant. So we'd understood that he was accepting that data was from him, but maybe that will be disputed at trial, but it doesn't much matter for your purposes today. And then at paragraph 34, he responds to the invoice, and what we say the reasoning here is contrived. Essentially what he says is 2 things. So he says 5 lines down, I would draw the court's attention at this stage to the fact, and then he sets out 2 facts which he relies on. He says, firstly, the claimant's invoice was in respect of 5% over target marketing fee, i.e. not simply a 5% share of whatever combined profits the claimant and defendant generated. So I think what he's saying is, well, why aren't they just invoicing 5% of the total total amount? If the claimant was right, they'd be issuing an invoice for 5% of all of the combined gross revenue. But obviously that ignores the fact that 40 million dirhams has been accounted for in advance. So that point doesn't go anywhere. The only reason for this invoice is because the target has been exceeded. If it wasn't exceeded, you just get the minimum fee. And then his second point is, he says, well, the figure of 7338, 5% of which is 366,900, represents on Mr. Manti's own evidence the amount of revenue generated by the claimant's sales agents above the sum of 40 million dirhams. Now, that's not what Mr. Manti says, and I'll show you that, because you were taken yesterday to a breakdown of what the sale agents who had previously been employed by the claimant, what they had been responsible for in terms of sales. But just think about what the case is now in terms of the defendant. Is the case now, therefore, that gross revenue is revenue generated by the sales agents who moved from the claimant to the defendant? Is that what's being said here? They're not committing to a case, but that's what's being implied. Or is it being said, as we'd understood the case to be, that gross revenue, when you look at it, involves some sort of assessment as to who is responsible, who takes the credit for particular revenue? And that seemed to be the case that was being advanced yesterday. And what my learned friend said was, well, you can go through the spreadsheets and you can pick out, for example, where a lead came from. Did it come from a L.l.c Habitat website? But these are two different cases. One is you take the gross revenue as a whole and you work out who gets credits. The other is, as appears to be from Mr. Texera's statement, hinted at least, what you do is you work out who were the agents who previously worked for the claimant, and then you work out how much of the revenue was generated by them. Those two things cannot be true both at the same time. Those are two fundamentally different approaches.
Has anybody done the calculation based on the spreadsheet as to what the figures would be if it was either of those cases was the real case, as opposed to your case, which is that this invoice represents the 5% of the excess over the target marketing fee? So, in other words, right. Does it work? Do you get my point? Does it work?
I get your point. So that let me just, I will answer this, but let me just explain. So you're talking about two different possibilities. One is where you just deal with the sales team. That exercise has been done. And that exercise was done by Mr. Fontmanti, and I can show you that. You've been taken to it previously, but that it just follows the document that we looked at, and you get to a sum which is similar to 7.3 million dirhams. If you recall, it's not the same sum, but my learned friend said, well, it's similar. Now, that's a misconception, though, because that sum would, on his case, if this is his case, amount to the total gross revenue, which would be below the threshold, the 40 million threshold. So you're not comparing like with like, you're comparing 47 with 7, not 7 with 7, if I can put it like that. So that case doesn't work, because anything you extract from the numbers that were delivered reduces below the number that was actually paid out, if I can put it like that, because the number that was paid out is based on all of the numbers in the spreadsheet, and that applies equally if you were able to do some sort of exercise where you went through and said, where does that lead come from? Nobody has done that exercise, and we say there is no rational way in which you can do that exercise, because if you ask yourself the question, who takes credit, the claimant or the defendant, for a particular sale, it's not possible to answer that question, because there are there are always two different sales functions. There's the marketing side of it, and then there's the actual conclusion of the deal side, and then there's the papering of the deal side. I'll come back to that. So you were
sorry, you will be dealing with clause 5.1M, I'm sure. I don't want you to take you out of your thread, but I do. Yes. This fits in with what we're discussing now, or yes, not. As you might.
I will come on to that. I mean, just to give you the highlights, I think we say 5.1M. It is about trying to measure KPIs for the purposes of the KPI clause. That's the context in which it is in. And actually, when you look at all of those KPI clauses, at the time of contracting, you can see this, I think it's 5.1K, but I'd have to look back at my notes. There is provision, or is it L? There is provision for the parties to agree a mechanism for tracking lead generation in the future.
Yes, it is K.
Thank you.
K1 and 2 specify what the KPIs will analyze.
And then they go on to hang on, I shouldn't do this blind, so I'll just turn it up. Beg your pardon. I think what they say, yeah, it's M on page 48.
Yes.
It says, oh no, it doesn't. Sorry, you're absolutely right. Yeah, sorry, it is K2, isn't it? That's absolutely right. Sorry, page 47 of the bundle. So K2, the online direct channels should be the first lead generation source of the business during the 5th year. And then this is the important bit. The methodology to measure it will be agreed between the parties once a complete online and offline lead tracking system has been implemented. So they didn't have, at the time of contracting, a mechanism to determine how to attribute a sale to a particular lead. And they needed that, or my learned friend's case, from day one. Otherwise, there was no way to determine who gets what, what are we taking 5% of. So we say that that is it's one of the strong indications that this is not what my learned friend says is trying to do. But I will come back to that. What I was just dealing with here was just taking you through the sort of background to what actually happened and how things played out. So the spreadsheet, which is the breakdown of the agents, is at 1147. And I think
just give me a moment. Yes.
And so this does the breakdown for the agents who happened to be in the claimant's team. Now, we say that this can't possibly be what was intended by the contract, because this is a 10-year contract. And so agents will change over the course of that contract. So the claimant's fortunes were not pinned to A, the prospects of the team that was in the claimant's employment, and B, whether they happen to end up staying with the defendant at the time. It's not clear whether that is a case that is actually being run on construction. It doesn't appear to be, but that seemed to be the suggestion from Mr. Texera. The other thing that was said in relation to this payment of the invoice, which appears on the previous page again, just to remind you, 1146. It was said, you asked my learned friend about it, and he said, oh, well, the payment could have just been authorized by someone in the fees department without anybody turning their mind to it. That's never been suggested before. If it is suggested, that is false. And had it been suggested, I'd be able to produce the evidence which shows that it is false. And that is evidence that will be available to you at trial. And it demonstrates why it is very dangerous to try to determine a factual dispute at a hearing like this, particularly when you were just having facts being lobbed in the course of oral submissions. My case will be that this payment was specifically approved by Mr. Azar expressly. Now, we don't have evidence of that, but I've seen it, and we would have put it in had my learned friend put this case forward previously. But in any event, there is at the very least a factual issue that the defendant paid a fee calculated on the basis of gross revenue, and that is one of the important facts we say that would go into the question of how you would interpret this contract, and if you don't interpret it as we say you should, whether you should rectify it. Now the amount that was paid obviously depended on how much was reported by the defendant. That's where the figures were coming from. And so, as you've heard, what happened was that quite fortuitously, the claimant discovered that there was this, at least arguable, but in our view clear, underreporting of revenue. Now, this started with a conversation quite out of the blue between Mr. Fontmante and another person who said, well, the defendant's had a good year. And he said, well, that doesn't match what I've seen, because I've seen revenue falling. He subsequently obtained photographs from a presentation given by the defendant internally. Now, you probably haven't had a chance to see these because they are quite, I'm afraid they've been reproduced in the bundle in a way which makes them very difficult even to see that they're there. But the page number is 328. And because of the size of them, you have to zoom right in, and the pagination, I'm afraid, rather obscures the numbers. But essentially, if you've got it and zoom in on it, there are a number of other pages. But this is a photograph of a presentation given by Mr. Azar to the CEO of the defendant. And what you've got here is him giving an internal presentation to his company where he's saying that the gross commission, you can see it on the right. You can see the transaction value on the left, the gross commission's on the right. It's very difficult to see, but what it does say when you...
Unfortunately, they've put the exhibit numbers and page numbers over the photographs in the bundle.
I know, and I'm afraid that's a feature of how the photographs have been reproduced, but I don't think there's any dispute about this. What it says is 228 million dirham. That is 2022 gross commission.
Sorry, just let me be clear which page you're referring to. So
it's 228. It's the bottom right of the photographs. So it's the last photograph.
328. I should be looking.
I think it's. Oh yes, you're correct. Sorry, 328. I do apologise.
328. So look at 328. So what I'm looking through is the page number, the exhibit number,
the
exhibit number, and what I can see is in the grey shaded half of the screen. It's a drop down screen, isn't it, from a projector? It looks like to me, and I see. Is it 228 or what is it? What is the figure?
It's the number is in fact 228.
228. And what's what's underneath it in white?
2022 gross commission.
Right. No, that underneath 228, there's another number in white which I can't make out at all. What's that?
Underneath 228, it says million.
Million. Ah, right.
228 million. So on the left, you've got 9 billion. That's the transaction value.
Yes.
Resale, off-plan, and project developments. Yes. So he's saying it's gone up by 16% compared to 2021, which was 7.7 billion. And then on the right, he's presenting internally that the company has earned commission, gross commission in 2022 of 228 million dirhams, right, plus 20%. That's Mr. Azhar.
Strutting about on the stage with his hand.
He's the CEO of the defendant.
Right, that's Mr. Azhar, is it? Right.
Yeah. So now in 2022, the gross commission that was declared by the defendant to the claimant was just over 48 million dirhams.
Just let me make a note. And sorry, give me that last figure again. The gross revenue that was given to the claimant was
48 million. 48.
48.
Just over.
Yeah. Right. Thank you.
My learned friend says there's no real prospect of success in this case, but we say that this is something that we should be entitled to ask the court to investigate, or to investigate through the court process. We say there are questions to answer here because internally, Mr. Azhar is saying our gross in revenue is 5 times what he's telling the claimant it is. And we'll come on to the various different ways in which it may be that the defendant is trying to say that some of that gross revenue wasn't its gross revenue, or wasn't gross revenue within the meaning of the contract. And I'll deal with that. But that is part of the case. Now, this revelation prompted Mr. Fontmante to inspect the customer relationship management system, the CRM system for the business. And that records all of the sales undertaken by the business. And that revealed a much higher number than was reported in the spreadsheets. And it was broadly consistent, not identical to the numbers in this presentation. So we don't know what the discrepancies relate to or how they arise, but the defendant has refused to provide any information about this. What we have,
What were the two figures? Just give me. I've seen them, but I want them for my note. Do you have them? If not, it
I do. If we go to page 1639, we'll be able to. It's actually pleaded out, so you can take it. You can take it from the pleading. I'm showing you the amended pleading, obviously.
Yes, that's where I've seen it. That's where I've seen it.
It's internal page 11, paragraph 16. And it's 16, I think. And it is paragraph, so you'll see the reported revenues in the Google spreadsheets for 2021. And then underneath that, I'm afraid it flips because of the amendments onto 2 pages.
Yeah.
CRM gross revenue shows 135,906 for 2021. So that's on the top of page 12.
Yes.
So then in 2022, we've got 49 million. I think I told you 48 million a moment ago. I'm sorry about that, but it's 49 million disclosed, and then the CRM was disclosing 238 million in revenue in commissions, and then we only have data for the first half of 2023, where what was disclosed was 22 million, but in fact commissions received according to the CRM were 200 million.
Yes.
So you can see the level of the underreporting. Just in the first half of 2023, we say the difference between the CRM data and the Google spreadsheet data was 178 million dirhams just in the first half of 2023. The results, so there is, as a matter of fact, a huge discrepancy between the revenue recorded in the spreadsheets and the revenue recorded in the CRM. And the defendant has given no evidence that could explain that, to explain how that comes about. So when my learned friend was talking about prime realty, when you've got evidence from Mr. Fonte about prime realty, those are conclusions, inferences that my client has drawn, but we don't know those things for a fact. We don't know that revenue has been diverted to prime realty. All we know is that you've got 2 figures reported that don't match, but then one is reported to us and one is reported internally.
Do the larger figures on the photographs of the presentation and in that you've extracted here in paragraph 16 of the amended particulars of claim, do they include prime realty revenue, or is that something that you've not been able to ascertain or investigate?
We believe so, but we can't know without understanding more about the data or seeing some of the contractual documentation. We simply can't know. I think Mr. Fontmante has seen some documents which suggest that at least some of this revenue has been signed under contracts, has been received under contracts entered into by Prime Realty. And I'll come on to how we deal with that. But he doesn't know that across the board. He's just seen some contracts. And the contracts all appear to have the same features, the ones that he's seen, which is that they all appear to be off-plan developments. Right. And so it may be that what's happening is off-plan developments, although they are, and I'll show you this in a moment, but they're being marketed in exactly the same way as everything else. They're just being, the revenue is just being run through Prime Realty. That seems to be what's part of what's happening, but we don't know it for sure. But just to show you the financial consequences of this, we pleaded out, if you go down to page 1641, so paragraph 21, this is just up to the first half of 2023 where we have the data from the CRM. We set it out, and you will see at the bottom right of that column, we add that up to just under 25 million dirhams, which is $6.75 million. So that's for the first period. But obviously during that period, you've got very rapidly accelerating growth. And it coincides with certain global events, Ukrainian war and so forth, which led to a very large increase in property prices in certain parts of Dubai, certainly, but across the board in Dubai. So our understanding is that this just reflects huge success in the business, which was not anticipated when the parties entered into the contract. And so you can imagine what we say about what is really going on here, which is that the defendants have signed themselves up to a deal which, in retrospect, they wish they hadn't done because they want to keep a larger slice of the pie. This first part, is based on actual data from the defendant's system. You will see that if one just takes alone the partnership fee for the first half of 2023. So you see this on page 13 of the document.
Yes.
And it's the column, so it's just next to, so just for the first half of 2023, if we're right about the revenue, the gross revenue, then the unpaid partnership fee amounts to 10.8 million or almost 10.9 million US dollars. And that's just a feature of the fact that the overall revenue of the business was multiples of what had been anticipated by the parties. Now, after this time, the defendant cancelled the claimant's access to the CRM system. So the numbers afterwards are based on assumptions. Of course, they have to be from our end. If the defendant's performance continued to grow at the rate that it was, these numbers will be underestimates. But again, the defendants simply refused to provide that information. So what we have simply done is assume that there is no growth at all, and prepared a further breakdown for the period up to the end of October 2024. You find that on page 20, paragraph 23.
I'm already looking at it.
Thank you. So you'll see the punchline at the bottom right is 29 million US dollars at present value. So total value by this point of unpaid fees up to the end of October 2024 is about, these aren't dollars, sorry, these are dirhams. This is 55 million dirhams. Sorry, and it was 10 million. I've been mixing up dollars and dirhams in my submissions to you. It's 10 million. For the first half of 2023, it was 10 million dirhams, of course, not dollars. And it was 25 million dirhams up to the end of the first half of 2023, and another 29 million dirhams after that. So now we're up to 55 million dirhams unpaid, we say. And then you get to October 2024. Why October 2024? Because that was the date of the pleading. And it was the date on which, in that pleading, we said, look, it's clear you're not going to perform this contract, so we accept your repudiatory breach of contract. Obviously, there's a battle about who was entitled to terminate, and I'll come on to that, but I'm just explaining why we calculated in that way. Now, pausing there, my learned friend complains about the next paragraph. And he said this is just a hallmark of exaggeration. There we plead out a claim for damages for non-payment of money. Now, that is a legally available claim. It's just a recognizable claim in law. Why would we not plead it? In fact, I've attended conferences where people have suggested it's professional negligence not to plead out a claim of that nature. And you may recall from the contract, default simple interest under the contract was 12%. As pursuant to the agreement. So this isn't an inflation of the claim. This is just a perfectly proper way to plead out a claim. Now, when it comes to how this revenue was being split out, you asked the question a moment ago, and perhaps I can just show you what we say about it now. Mr. Fontmante's evidence about the prime realty issue, you can find at page 1081.
I've read it, but I'll just look at it again.
Thank you. So he explains a little bit about it, and what he says is paragraph 92. He's responding to the suggestion from Mr. Texera that prime is merely tangentially related. So that's the factual allegation from Mr. Texera. It's tangentially related, and then he he sets out a number of points to say, well, it's a bit more than that, we think, and this is why. We don't have all the facts. We're working a little bit in the dark, but we're doing the best we can. So number one, he notes that they have an identical shareholding to the defendant. The same people own it. Number two, it lists out identical business activities to the defendant. It identifies itself as a real estate broker. Number three, its license was issued on the 14th of February 2022. So that's just before the amendment to the agreement. And that is when we say underreporting really starts to kick in. The underlying documents are in the bundle. I can take you to them if you'd like me to, but I don't necessarily need to.
Not necessary.
Thank you. It shares the same company address. That's at 92.4. It's got the same, and this is important, it's got the same employees as the defendant. And not only that, 92.6, the employees presented themselves to the market as the defendant's employees. So just pausing there, perhaps I can show you this. So for example, if you can just go to page 1300 of the bundle and zoom in there, you will see a Mr. Deepak Bosco who lists himself. If you scroll down, his experience, this is a LinkedIn page. He's a sales manager, project developments at L.l.c Habitat at Sotheby's. And then if you go to page 1304, you can see Prime Realty, top left, if you see that, the Prime Realty Real Estate LLC.
Yes.
This is their registered brokers, and two boxes down on the left, you'll see Mr. Deepak Bosco. And you will see that he lists his l.l.c.habitat.sar.com email address as his contact. And you can do that with all of Prime's agents. You're
just giving me one example.
I'm just giving you the one example.
All appear across the two platforms, do they?
It seems to be. I'm not sure we can track them precisely all to their LinkedIn processes, but they all are the defendant's employees. They all are using L.l.c Habitat SAR, were using L.l.c Habitat SAR email addresses. Maybe one or two is different, I think.
The one next to...
Yeah, there's one next to him that isn't. You're absolutely right, but almost all of them otherwise, I think, are. There's a few differences, that's not right.
Sarah Sabai, is it Sabal? Down different. Oh no, she's got L.l.c.
And in terms of, I think things like, I mean, we'd have to look at what the email addresses, for example, DubaiCanalFront.com are.
Yes,
and they may well be associated with particular developments. So I won't go so far as to say they all do that, but what appears to be the case, these are, we believe, we understand, these are the defendant's agents. That's the evidence of Mr. Fontmante. We were at page, I think, 1082, back in his evidence. And so just going down that list, we're at 92.7 now. The Prime and the defendant use the same logo on the Dubai Land Department's website. 8, its license uses a L.l.c Habitat Sotheby's email address and domain name. So 9, all the team members under Prime's license were clearly associated with the brand that both the claimant and defendant were using during the term of the PSA. They all had email addresses using the L.l.c Habitat Sotheby's domain name. I think, I'm not sure whether that is based on that document that I've just shown you, but well, yeah,
I can see some didn't, or advertised different email addresses, but from looking at it, the substantial majority use the L.l.c Habitat email address.
Well, they used to, because the next point is that at subparagraph 10, since the 2023 rebranding, he says a review of the Dubai Land Department's website shows that those same employees under Prime's license now use a branded SIR email address, and Prime and the defendants still share the same logo. There are other points as well. So 11, Mr. Texera's telephone number appears on its VAT certificate. Number 12, all of their employees of Prime were presented to the market on Lux Habitat Sotheby's website. And 13, they all appear in Lux Habitat Sotheby's CRM system. So they're all agents for those purposes too. They're all on the company's LinkedIn site, that's 14, and they're all on the Global SIR website, that's 15. Now, it's said that these complaints are not pleaded. There is a fairly detailed pleading on this. In fact, you weren't shown the pleading. It was just said they weren't pleaded. 1640. It's paragraph 17 of the pleading. There's 8 points that are raised there, but the central ones we say are raised, and there's certainly enough there to say that there is a real prospect of establishing that they are affiliated. Now I'll come on to what affiliated means, but we set out facts there about their association. And obviously the reason why it's important is because, or might be important, is because the gross revenue was defined to include revenue of any other affiliated company. So just looking at page 40, which is in the contract. So it is the internal page 2 of the document. Yes. It's the fourth. Unfortunately, it's the 4th page of the document. So gross revenue. So that says is the total amount of monies generated per year by the seller and any other affiliated companies, subsidiaries, or employees. Now, I'll come on to this. I'm not going to deal with it right yet, but as you've heard, we say the reference to the seller is quite plainly an error and can be corrected by construction, or if that is wrong, we claim rectification. I'll come back to that on the immediate judgment application. But subject to that point, so just if we can get over that hurdle, one of the questions will be who generated the revenue that we see in the CRM. And it's generation of revenue. So if it turns out that Prime Realty generated the revenue within the meaning of the contract, that's a big if, then there will be a question for the court at trial: is Prime Realty an affiliated company for the purposes of the contract? But there are a number of steps before we even get to that question, because the first thing is, well, our overall case is that everything in the CRM amounts to combined gross revenue. First, we say either it's money generated by the defendant, just because Prime Realty is receiving that money doesn't mean that it's not generated by the defendant. It just means the defendant's concealed it by routing it somewhere else. So that's the first point. And obviously that's a fact-sensitive issue, which will require investigation about how that revenue was generated and how it was received. The second point is that you will see that the gross revenue refers to monies generated by the seller, insert the buyer for present purposes, any other affiliated companies, and then it says subsidiaries or employees. So the next question is, was that revenue generated by the defendant's employees? Even if it wasn't generated by the defendant. I apologise, I've got background noise.
I'm not hearing.
And we've seen, I'm grateful. We've seen that there is clearly an overlap. We say potentially a complete overlap between the sales agents employed by Prime and the sales agents employed by the defendant. And so there will be a factual question about whether or not those agents, those employees of the defendant, generated this revenue. And then the third point is, well, all right, assume we're wrong about those two factors. If it is right that Prime generated this revenue within the meaning of the agreement, is Prime then an other affiliated company? And we say it is. It's not operating independently at all. It's using the defendant's sales team, presenting as the defendant, but then booking revenue as the defendant. So it's only at that third stage that you actually get into the question of understanding what an affiliated company means under the terms of the contract. Now, just to show you the factual bits, at 1084, Mr. Font Mante has looked at the deals which he thinks may have been booked through Prime. This is all tentative because we don't know. And so at 93.1, he says it looks like they may be ones that are generated from exclusive off-plan sales. And so he makes the assumption, well, maybe it's all of the off-plan sales, but we simply don't know. And we've got no help on this from the defendant.
Are these all off-plan sales, A to T?
Yeah, at 93.3, yes. So he says, I don't know which projects have been transacted, but these are the off-plan real estate projects that were marketed and transacted include all of the following. And so he lists them. And his evidence is that all of those were sold by the defendant using the brand and the website. So you can see that at paragraphs 93.4 down to 93.10, some of the highlights. So 93.5, the printed marketing materials for all of these projects was all under the brand or under the co-branding. And he presents, if you want to look at them, some of the marketing materials. 93.6, even the showroom was co-branded. At 93.7 and 93.8, they were marketed on the claimant's website, and they all had their own listing pages. 93.9, the claimant actively helped the marketing of those projects and even went to some of the sales meetings. 93.10. So what we say is that there is no principal distinction between the way in which these projects were sold and the ones which are included in the Google spreadsheets. There's no principal distinction which could justify the exclusion of those projects from the revenue that's been reported by the defendant to the claimant. And so our central case is that the defendant's obliged to pay a partnership fee on all of that revenue. Now, in 2023, the defendant tried to renegotiate the terms of this agreement. There seems to be a dispute about that, but it was combined with this decision by the defendant that they wanted to rebrand unilaterally. They didn't want they asked for the agreement of the claimant, but they said we're entitled to do what we like. And there was a disagreement about whether it was entitled to do that. And the claimant approached the court, and you've heard a lot about the interim application that was made. And it's right that the court refused the application. I don't accept the characterization that the court that somehow found that it was an application that should never have been made, or that it was an absurd application or anything like that. The judge looked at the clause, the particular clause, decided that it didn't prevent unilateral rebranding on his interpretation of it at that time. And on that basis, there was no contractual entitlement to resist and therefore to get an injunction. And that is the basis on which it was dismissed. Now, I'll come on to what the status of that is, but I think it's accepted that those findings are not binding on this court. And so, in principle, those are open to being argued again. That's the corollary of not being binding. If they are binding, we can't argue them again. If they aren't binding, we can. But I'll come back, and I know Your Honour has questions about
I do.
that issue.
I made it plain to you. I've not made any decision.
Understood. Understood. I wasn't intending to suggest you had, but I understand, and I will deal with it.
It leaps out of the pleading as, on the face of it, as being in contradiction of the interpretation by the judge, right? So my concern is that you're going to have to deal with that in relation to the extent to which it forms a fundamental part of your case. The question is, of course, whether there's any real prospect of succeeding in what a contrary argument or a contrary interpretation.
Not quite.
Well, go on.
Because
your position.
Because it's this bit of the case is argued on the basis of abuse.
Yes.
So this bit is argued as an abuse. It is said it's a collateral attack on a pre-existing judgment.
I have that.
But
yes.
a collateral attack requires a binding finding. So it is not an abuse. The application is not put on the footing that, by the way, if you are allowed to run the point, you've got no real prospect of winning on the point. The way the application is put is as a strikeout of the claim because it is a collateral attack. That is the only bit of my learned friend skeleton which takes aim at that particular paragraph. Sorry. Now, on the real prospects of success, I can deal with that, but we said that's not what this hearing is about in relation to that narrow issue, and I'll come back to it if I may. But so where do we get to? So the claimant's position is that the defendant had no right to terminate before the end of 10 years, and nevertheless the defendant terminated. We say its reasons for doing so do not justify termination, and if we are right about that, its termination and its conduct in saying we're not going forward with this contract is itself an anticipatory repudiatory breach, and we have now accepted that in our pleading. So that does bring the contract to an end, and that entitles us to damages, which need to be assessed. And we have calculated what those damages are likely to be, and it's paragraph 32 of our pleading. And it's over the page. You will see the calculation, and we say that is conservative because it assumes no growth in revenue. Now, the defendant might come back and say, well, that 2023 was our best ever year, and so you can't base it on that, and here is the data to prove that. But they haven't done that yet, so this is the best we've got. And it applies what we consider to be a generous discount rate for accelerated receipt. I believe it's at 12% discount rate. And this will obviously all need to be updated for the date of the judgment. So it's discounting for things that when we get to judgment won't be discounted for, because by then they'll be in the past. So the number's going to go up. And it assumes what we say is a pessimistic cost rate of 55% of fixed fees. My learned friend said yesterday, our calculation does not take into account costs. That is just not right. It's wrong. It does. There may be a factual dispute about whether there should be more costs, but essentially we say the claimant's costs wouldn't have gone up by very much, because this in large part reflects a surge in prices, which brings a surge in commission, which brings a larger partnership fee. But the calculated value of that is 81 million dirhams. And that is, I mean, my learned friend said it's all exaggerated, but he doesn't actually take aim at any of the elements of the calculation. He just says, well, the number's too big. But it's not a surprising number. What we get to in total is 135 million dirhams, which is about $36 million. But that's for a 10-year contract. It covers revenue that's missing for the most of that period, most of that 10 years. And as I've said, by 2023, we are running at 6% of about 400 million dirhams a year. So it's about 24 million dirhams a year on that calculation, about 6.5 million a year. So it's not surprising that with discounting, you get to about 36 million. In addition, as you know, we plead out a claim for additional damages under Article 42, and I'll deal with that when I come on to deal with the immediate judgment. So that's an outline of the claim. Your Honour is well familiar with the legal principles associated with this sort of application, and I'm not going to labour them, but if I may just pick out one or two passages very briefly that might assist, at least just for putting in judgments in due course if needs be. But for summary judgment, the burden is on the applicant. The test is whether there's a real prospect of success. This is not a vehicle for deciding disputed issues of fact, although applicants regularly try to persuade the court to engage in a mini trial. That is discouraged, and we say that is what the defendant's essentially inviting you to do today. That is wrong in principle. In this court, the case that we have is GFH Capital and Hay. That's probably the one people refer to the most. That is at page 2054. And paragraph 9 sets out the principles fairly briefly, and I'll just show you a few. Paragraph 3, we avoid mini trials. Paragraph 4, it's right, you don't have to take all the evidence at face value, but paragraph 5, the court should avoid being drawn into an attempt to resolve those conflicts of fact, which are normally resolved by a trial process. 6 is you have to consider not just the evidence available today, but the evidence that will be available at trial. And that's important in a case like this, where one party is operating very much in the dark. There'll be a lot more information about what revenue was generated, how it can be characterized, and whether that fits in with the definition of the contract. Paragraph 7, over the page, sorry. Allegations of fraud are particularly difficult because they often rely on inference, and we would add that difficulty is true whenever a party seeks to draw inferences, and we're obviously operating at least in part on inferences here. Paragraph 9, the burden there was on the claimant because it was the claimant's application, but everyone accepts it's on the defendant here. Paragraph 10, you should hesitate where there are reasonable grounds to expect a fuller investigation of the facts would alter the evidence at trial. So that's all I was going to say about the test there. I don't think any of that can reasonably be in dispute.
Just on one matter that I raised yesterday, Mr. Potts. The claim for additional damages, Article 40, sub-Article 2,
yes.
You rely on the fraudulent nature of the deprivation of the revenue. You don't. Is he right in saying you don't actually plead a case of fraud as such?
I think we say it's dishonest.
Yes, you do. Dishonest, deceitful. I think I've picked that out. If not in the pleading, certainly in the.
If the question is it Derry and Peak deceit? There's no tort. There's no tort claim for that. No, we don't need it.
No, right.
We don't need it. But that we don't need to plead a deceit claim.
No, I didn't suggest that you did. Yeah. It was just the way in which the question I asked was responded to. The position is clear to me from the way in which you have pleaded this part of your claim. So you needn't trouble further.
Thank you. All right, thank you. So just dealing briefly then with the strikeout provisions. You've got the cases on this, I'm sure, as well. But essentially, you assume on this the facts asserted by the claimant, and we know the particular basis of for strikeout that's addressed in this application is it's said that the parts of the claim or the whole of the claim is an abuse. As I've said, there were 3 grounds of abuse in the application. Only 2 of them are pursued in the skeleton, and one of them's been dropped orally as well. But we do say, and this was repeated in opening, that it is simply wrong to say that my client was trading without a license. That shouldn't be alleged. To clear that up, page 1096, that is the commercial license, and you can see its expiry date 15/11/2025. That's about a third of the way down on the left, and on the right you'll see issue date 16/11/2009. So it's continually been in place. Now, obviously, it is past now, the 15th of November 2025, because this is the document that was in place for the original hearing back in June. The issue arose, it seems, because Mr. Texera, in his witness statement, said he thought that the claimant's license expired in November 2023. And you can see what happened. He's just had the certificate for 2023, looked at it and said, oh, well, it must have expired, but he hasn't seen the one for 2024 or the one for 2025. So there's no basis whatsoever for alleging that the claimant has been operating without a license. It's quite a serious allegation, and it's a false allegation, and it's repeated by counsel in writing and orally, and it shouldn't be. And that is unfortunate. Two arguments therefore remain. First, Henderson abuse, and second, these points about confidential information. So let's start with Henderson abuse, and I know Your Honour is very familiar with the concepts here. Again, if I may, I just wanted to show you some very short passages and remind you of some of the principles. 2639, paragraph 65. The starting point is that it is a strong thing to strike out a meritorious claim. And there are many reminders of that in the case law, and that's repeated in the Stewart and Goldberg case.
So common. Paragraph 65, did you say?
65. The cases on this aspect of abusive process include many reminders that a party is not likely to be shut out from bringing before the court a genuine cause of action. And down by D, at common law, it must be clearly shown to be an abuse before it can be struck out. The court must consider critically any suggestion that a particular cause of action should not be allowed to be asserted because of the bringing of other proceedings based on a different claim. A typical example of abuse is where the claimant is really trying to relitigate a claim or contention already unsuccessfully advanced. It is so that's the first point. The second point is it's necessary but not sufficient to show that a claim not only could have been raised before but should have been raised before. So there are three parts to that. Could it have been raised? Should it have been raised? Is it an abuse? And it is wrong, as a matter of principle, to find that just because a claim could have been brought, it should have been brought. And that's Lord Bingham in Johnson and Gore Wood. You know this case well, but so you can find it. It's 2321, page 31, and it's next to B and next to C.
I applied it quite recently.
Very good. I won't label it.
I performed that exercise that he, which is why I referred to it, because all of the other authorities speak in terms of principle. What Lord Bingham does, he tells you how to deal with it, how to decide it, how to approach it, which is why it is, if you like, my favourite decision on abuse of process, Henderson abuse. It should be renamed not Henderson abuse, but Johnson Gore Wood abuse.
Yes, that's probably true. So, I mean, you've got the points on this. I was going to take you also to page 59H.
Just give me the page reference for the Johnson Gore dictum. I know it's in the skeletons, but I'm making a note as I go along as well.
Yes, certainly. So the bit I was going to show you was at page 2349.
Yes.
And it's page 54H, so right down at the bottom, 59H of the report and to over the page. But the point he makes there is that there is often entirely sensible, it's often entirely sensible to advance claims separately. And he says there is no presumption that...
Sorry, which page are you on now?
It's down 2349, it's down by H.
This is Lord Millett.
This is Lord Millett's speech, as Lord Justice May observed. Yes. He says in a particular case it may be sensible to advance claims separately. In so far as the so-called rule in Henderson and Henderson suggests that there is a presumption against the bringing of successive actions, I consider that as a distortion of the true position. The burden should always rest on the defendant to establish that it is an oppressive or an abusive process for him to be subjected to the second action. And in this court, at least, and there's been argument about what it all means in England, but in this court, this has been looked at in a case called Amira, and that is, you can find that at 1880 in the Court of Appeal. And I'm afraid the report is rather comes out like this, but happily it's not a problem for this passage. It's paragraph 8 of that.
What was the page number?
1880. 1880.
Thank you.
And this is a decision in a mirror in the Court of Appeal, and the court essentially looks at the authorities and says it's usually necessary to show that a party is being unjustly vexed, harassed, or oppressed by the claimant. And you can go down to paragraph 10 on page 1881. And if you look at the bottom, the final sentence, in our opinion, in all the circumstances includes a consideration of whether failing to include all claims in one action and alleging one or more related claims in a separate action is vexatious or oppressive. To justify striking out the second claim, it must be shown not only that the same claim could have been brought in the first action, but also that it should have been, and should have been, I'm afraid that's been obscured, but essentially says it would have conveniently fitted into the first action, raising the same issues or turning on similar facts and circumstances, but also, and this is an important part of the circumstances referred to above, because to bring it in a separate action subsequently would be unfair, abusive, vexatious, and oppressive to the other party. So they say it's not really three parts, could, should, and vexatious and oppressive, but vexatious and oppressive fits into the should. The other aspect of this is that there's a cards on the table approach, which is known as the L.l.c principle. In a sense, if you store up claims for future without telling the court that you're going to bring them, you deprive the court of the opportunity to case manage them and say, well, actually, we should put this all together. And if you do that, you run a risk of abuse. And so in that context, the court has to ask itself, well, if this had been raised with the judge, what would the judge have done? And so sometimes there's a sort of counterfactual examination of that. And in particular, would the judge have said, well, that claim has to be brought with the first one? And that principle has been adopted in the DIFC as part of its overarching assessment. And you can see that in a mirror at page 1883, paragraph 16 and following. But in the interest of time, I won't take you through it. But the point here is that when one thinks about the L.l.c principle, that really does emphasize that this is a practical complaint. It's not a technical argument where somebody says, you missed your chance, or you should have done it, you could have done it then. You have to ask, what difference would it have made if things had been done differently? And is the way it's being done now, because of those differences, unjust, oppressive, vexatious?
Well, I asked that question yesterday, perhaps a little clumsily, with dealing with Part 8 and Part 7 claims, you'll recall. What's your position on that again, for clarity's sake? You say that it wasn't practical, having notified the judge that this claim was on the stocks, as it were, if I can put it that way. It wasn't practical to go back under the same case number and convert the Part 8 claim to a Part 7 claim. Is that your position, or what?
Yes, so I can develop this, but fundamentally, the way it was put in orally was completely different to the way that it's been put before. So the way it's been put before is that there was a substantive claim, and that's not true. And my own friend should know that. The way it was then put orally was, well, we should have gone back and amended it into the original claim form, but we can't do that. You can't bring a Part 8 claim which you know is going to raise disputed issues of facts.
Yeah. Sorry, just give me 1 minute. I've got a matter of concern. Sorry. Yeah.
Not at all.
Sorry about that. Sorry.
No, not at all. Not at all. The point, it's been said to be in the past, and I mean, again, this is the problem of just simply lobbing out new arguments as we go, because there's plenty of authority in England about the circumstances in which bringing a claim in the wrong way, because it attracts different fees, if you do that deliberately, that could in itself be abusive. Because if you're trying to avoid the fee regime of the Part 7 claim and just make it a Part 8 claim because that's much cheaper, as it undoubtedly is, then the court won't allow it if that's what's being done.
Yeah.
And so, of course, we can't convert a Part 8 claim form into. There's a number of factors, but procedurally it shouldn't be done. It really should. The court should not be saying you should have done this. You should have used the wrong procedure. I mean, that to me is a very odd suggestion, and it was mixed up with a series of very confused submissions about suggesting that the first claim form was an abuse, which of course it wasn't, because it was done precisely the way that these things are done in this court. So the way it always works on an application for interim relief, take a freezing order, for example, you will have seen this. You'll have a Part 8 claim form for the interim relief, and then you will have either a Part 7 claim form for the substantive claim, or alternatively, if you can issue the substantive claim first, you'll issue it first and then bring an application under Part 23. But if you can't issue it first, you'll have to have a Part 7 claim form for the substantive claim, because the Part 7 claim form is very unlikely to turn, in most interim relief cases, on things that can be decided simply on the short form Part 8 procedure. So but the next question is, well, what's the difference? Because ultimately, say we'd gone back and amended that first claim form, we'd have had to do it firstly after the expiry of the mediation period, and which we got. Well, I'll show you this in due course, but ultimately they said no, we're not going to mediate, and it was only then that we could even contractually bring a claim, and that was 3 weeks before the hearing of the interim relief. So we would have had to do it in that period. So what would have happened then? It would have blown up everything. But in any event, you wouldn't have had a determination of that claim at that hearing, or indeed at any hearing, even if that hearing had been adjourned to look at the question of interim relief. You would have had a listing for pleadings, case management, trial, just as we're going to have now. So you asked the question, what difference does it make? My learned friend said, oh, well, what they're doing now is they're taking witness statements from the previous proceedings and saying, well, that supports my case. But how is that any different from what would have happened if we'd amended it into the first claim? It would have just happened to have the same claim number. We would still be saying, look at what you said in your evidence in response to the interim relief. I'm going to deploy that at trial to show that what you're saying can't be right. So it makes no difference. And that is, we say that one of the fundamental problems, I mean, it's fundamentally misconceived to say you brought an application for interim relief. Well, now you're shut out from bringing a claim for substantive relief. My learned friend can show you no case where that has ever been decided, because there isn't one, because it doesn't make any sense. The other hallmark of abuse which is relied on is that the second claim might be a collateral attack on the first. But as I said, that collateral attack is an attack on binding findings. And in that context, I think it's accepted, and I think you'll appreciate that no issues are finally decided in an interim application. We rely on Spencer Bauer. It's at page 2617. Just to show you very briefly, paragraph 5.32.
2617?
Yes. Paragraph 5.32. I'm just going to show you two sentences, if I may. The first one, the dismissal of an interlocutory application on procedural grounds or the merits is not final and does not bar a further application. And then further down to the next full paragraph, interlocutory orders in matters of practice and procedure, such as interlocutory injunction, remain under the control of the court and subject to review. Such orders do not decide any question finally, not even where there should be an interlocutory injunction or its terms. And my learned friend accepted orally that they are not final and binding.
Sorry, can I just say I accepted they were not final, but I did not accept they were not binding.
Well, how can they be binding if they're not final? No non-final decision is. I mean, that's just another example of an off-the-cuff submission that my learned friend makes, which is totally unsupported by any authority and makes no sense.
The judgment. The judgment.
Gentlemen, no arguing, please, across the wires. You will have a right of reply, and I will hear from you now, Mr. Montague-Smith, and we can move on from that particular issue, please.
So, well, if we go over the page, then if it's being said that there's a distinction to be drawn here, at the second paragraph down, the passage goes on. In Midland Bank Trust and Green, Oliver J. said that the decision striking out a pleading was final for res judicata. It suggested in the third edition that this was not correct. However, the decision would ordinarily be followed in the same proceedings. However, if the appellate decision changed the law in the meantime, and so forth. So it's not correct, was the answer, that a decision on even that is final and binding for res judicata processes, for purposes. So in terms of, I don't know whether I've managed to clear up the situation in relation to what actually happened at the first claim. The claim form for interim relief you've seen, that's at page 176.
Yes.
And you'll see there's no substantive claim in there. The rule which required that be brought by Part 8 claim form is Rule 2315. Rule 2315 reads, all applications made, sorry, it's if you got the book, it's at page 459.
I have the book.
Page 459.
Thank you.
All applications made before a claim is commenced should be made under Part 8 of the rules unless the court orders otherwise. So that's why it's done in that way. So when my learned friend says in his skeleton arguments at paragraph 9, I showed you this, but he says, paragraph 9, third line down, L.l.c filed brief details of claim alongside the Part 8 claim form, which included the following. And then he goes on to say, paragraph 16.2, L.l.c deliberately chose to issue a freestanding and substantive claim against SAR. Its brief details of claim included claims for damages for the alleged underreporting. That is just not true. What happened was explained in the skeleton argument for the hearing of the injunction application. So just to show you this, page 1798, paragraph 64. The bottom right of the page, an applicant would normally be obliged to undertake to bring substantive proceedings immediately in this case, clause 19.2 of the agreement requires mediation first. And in the circumstances, the claimant has prepared brief details of claim, it will bring. But obviously, this was for the ex parte, and there was no order made in relation to that. They just relisted it. The judge relisted it for inter partes hearing. But ultimately, what's being said is, well, we can't undertake to bring the claim now. So because we can't bring it now because of the mediation provisions, which you've seen. Those are, by the way, on page 53.
Yes.
So in his written case, my own friend simply mischaracterizes the brief details of claim document as a claim which was brought when it was not. And it was clear from his skeleton argument and the subsequent skeleton for the inter partes hearing that they knew that the issues that were being dealt with at that hearing did not involve the underreporting claim. So in our skeleton at 981 to start there, so this is for the inter partes hearing, 981 it starts, 982, paragraph 3, we say in terms, no remedy is sought on this application, refers to the understatement, and says no remedy is sought on this application in that regard. The underpaid fees will be the subject of the substantive claim. Dee's conduct has been dishonest.
Sorry, I was making a note of the point and the previous point on the error, I'll call it, in the skeleton argument. Just go back to the page number that you're referring to now. What page is that?
982. So
982.
this is the 982. This is the subsequent skeleton argument.
This is for the inter partes hearing.
Correct. And makes clear no remedy is sought in regard of the underreporting. That's paragraph 3. And they understood that because at page 966, you've got their skeleton.
Yes.
and it understands the case, claimant's application for interim injunctive relief brought by way of an amended Part 8 claim form. And then when it deals with the underreporting evidence, it does say very briefly at 969, paragraph 8.4, it just says, well, it's all irrelevant. So it was always the case that there would need to be a subsequent claim. But in the event the undertaking was not accepted because no order was issued. And this illustrates, we say, the fundamental misconception of this application. A complaint about abuse is about being unduly vexed twice. And yet there was always going to be a subsequent claim, even if we'd done it the way that my own friend now says we should have done it. I've explained why we say that we couldn't have amended it into the claim. I've explained why we say it wouldn't have made a difference. But we do say it was entirely sensible. Indeed, this was the only way that we could have done it. We considered that there was an urgent need to get the issue of branding before the court. The contract by that point was still ongoing and had not been terminated. So only the first $6 million of revenue was known about anyway. And so the vast majority of the claim simply could not have been brought at that stage because it hadn't been incurred yet and the contract was ongoing. But it was nevertheless, we say, sensible to get the urgent issue on first. And we could not bring the substantive claim because we were constrained contractually not to do it. We do say it's important that the prospect of another claim coming was flagged with the court. And that put the court and the defendant on notice that that was what we were proposing to do. There would be a subsequent claim.
Mr. Smith, I don't want to interrupt you, but I was going to take the substantial break we take in Dubai. We're 5 minutes past that. Do you want to finish this point and I'll then adjourn? Or how long do you think you'll be in doing so?
No, I'm very happy to adjourn as you like. I might be another 5 minutes, possibly 10 though. But right. So I don't want to put anyone out of their lunch.
I don't want to make anybody uncomfortable. So I'm going to adjourn now. It's 9:35 in the UK and 13:35 in Dubai. So we'll resume. Have you any rough estimate of how long you think you'll be in total?
I think I might be a similar amount of time to my learned friend. So I'm going to need most of the day, I suspect. Very well.
I will give everyone nearly an hour, and we'll resume at 10:30 UK time. That will be 2:30 Dubai time.
Thank you.
That's right. Yes, 40, adding up. Fine. Right, we'll adjourn now and we'll resume at that time. Thank you very much. Yes, gentlemen, we are returned. Mr. Montague Smith, if you'd like to continue.
Thank you very much. All right, I was dealing with the abuse arguments. I mentioned that it was considered sensible and that an urgent to deal with the interim application, but that the claim itself could not be brought for a variety of reasons. First, it wasn't complete. Second, it could not procedurally have been brought with the other claim. I mentioned the mediation clause, which you're aware of. It was suggested that our characterization of what happened in relation to mediation was not accurate. But just so you can see it for yourself, you're aware of the clause. It's clause 19.2, 19.3. I won't take you to that unless you'd like to see it. That's at page 53.
I have that well in mind.
Thank you. But the correspondence in relation to this, we don't have the mediation notice itself, but you can see at page 962 reference to it in the correspondence between the parties. I won't read it all out, but you will see 962 the bottom, an email 21st of August, and it refers to the mediation notice. You then can see above that there's discussion between the lawyers. And at 960, The defendants team say the legal representatives will participate and management will not. And there's some discussion about that and discussion about dates, but you see at 959, a mediator is appointed, and then there's further discussion about the dates just above that. But the response that ends it is at the top of page 958, where the defendants representatives say, in view of the nature of the correspondence we've received from HEDF yesterday and today, our client has concluded that mediation at this stage would not be productive. So they call a halt to that. That's the 31st of August. And of course, the hearing for the interim application was on the 22nd of September, so 3 weeks later. So at the time of the claim being issued, it obviously, it was not possible to bring the subsequent claim. And then that leaves effectively 3 weeks to do it, to bring a new substantive claim in that period. But ultimately, there was no obligation to do that. There was no binding undertaking, and in practical terms, it wouldn't have been possible in any event for the other reasons that I've mentioned. You couldn't amend it in, you'd have to start a new claim, and it wasn't complete anyway, because you only have a claim for the debt up to a certain point. In their skeleton argument at paragraph 16.1, the defendants make some further points. They say L.l.c made extensive allegations about underreporting. They say SAR was put to significant time and expense in addressing the allegations in its evidence and in its oral submissions. We suggest that's an exaggeration of the position. If you look at page 374, you see the sum total of the evidence from Mr. Texera. It starts at paragraph 74 there. This is his evidence in that claim. Paragraph 74, he accepts, he says he understands that it's not subject of this claim, although not the subject of the claim. So compare that to what was said in my learned friend's skeleton argument. Paragraph 75, he says he considers them to be irrelevant. That's the third line down. And then he says there may be some commissions due. At paragraph 76, it's possible that the claimant might be entitled to some commission in excess of the sums that the client's been paid to date, but $6 million, he says, is absurd, although he provides no detail behind that. And then notes that the contract provides for an adjustment and that there's a mediation process, and that's it. So there's no detailed explanation of figures or anything of that nature. Council also says in that skeleton that I showed you, 16.1, that a significant time and expense was spent addressing this in written argument. You've seen this, 969, just to remind you, is the skeleton, and paragraph 8.4 is all that was really said about this in written argument anyway. And the position throughout was that it's all irrelevant, and effectively the judge agreed. So what it comes down to, this amending point really ultimately is about timing, it seems to be, and essentially they're complaining that a claim should have been made sooner. It's been confirmed it's not being said that there's a contempt, and there would be a contempt if we'd given an undertaking and breached it. So as I understand it, that's not the way the case is put, and it's not suggested, certainly not in the written case, that that's what's being said. Henderson abuse is not about timing in the sense of when you bring a claim. It's about doing things twice, unduly harassing someone in a second claim, which with something that should have been dealt with in the first one. And ultimately, I've made the point that had we done it sooner, it wouldn't have affected the central complaints. We just would have got here sooner. It's not the central complaint being, well, we're going to have to give more evidence about this issue and deal with it more fully. So we do say that there just is no arguable Henderson abuse in this case. The other ways that abuse are put skeleton at paragraph 16.3 is that the claim is exaggerated, and that is evidence of a vexatious and oppressive claim. But as I mentioned at the outset, as I went through what my case is, the defendants filed no evidence whatsoever about what gross revenue actually was, how it was earned, how it was distributed, why the CRM system reports much greater revenue than the revenue that was reported to the claimant. And I've explained to Your Honour in a bit of detail about how the claim is calculated. I mean, fundamentally, as I say, if you are dealing with a 400 million dirham revenue per year, you get to fees of $6.5 million a year. And that is why over the course of a 10-year contract, most of which we say has been underreported, you get to a claim of the size that we get to, which is $36.5 million. And then that obviously gets bigger because of the multiple damages claim. Now, the additional damages, I'm not going to deal with that right now. I'll deal with that subsequently, because if it's right that there's a real prospect in relation to that, the claim cannot be abusive in relation to the 40 subsection 2 claim. So it really comes down to the argument that there's just no real prospect on 40 subsection 2. So I'll come on to that when I deal with the immediate judgment application. And then finally, paragraph 17, we get to this point about an impermissible collateral attack on the French judgment. The footnote, the only pleaded allegation referred to is paragraph 29.3 of the particulars of claim, and you have that point well in mind. So in other words, if there's anything abusive about this part of the pleading, then that's the bit that gets struck out, and not the whole of the claim, obviously. And in reality, we say, I think I've given you in broad terms my position on this, but I'll just make clear that this is a striking out application that's been made, this bit of it. So we're not looking at real prospects at this stage in relation to this allegation. The basis for striking out is said to be abuse on the basis of collateral attack, and collateral attack requires a binding finding, and the judge's decision being interlocutory does not lead to an issue of estoppel, because it's not final, and we say not binding. Obviously the outcome would bind if an order is made. If an interlocutory order is made, it's binding in the sense that you have to follow it. But the question then becomes, well, is there an issue estoppel that arises in the course of those proceedings? One of the friends says, well, he accepts it's not final. Well, then that dispenses with any issue estoppel in my submission. And this issue estoppel arises if on a final and binding finding. That's an essential part of res judicata. So we say that really means that there can be no collateral attack. There's no Henderson abuse. If we get to the question of real issue to be tried on this, do I have an arguable case on this? If it's not, if Justice French's judgment is not binding, then you do have to come to this afresh. And let me just show you what I say about this, if I may. It's in the contract paragraph. It's page 46. So it's internal page 8, and it's clause 5.1G. So the way we put this is to say, look, 5.1G says, during the term of the partnership, the buyer and the seller have agreed to implement a co-branding strategy to combine the market strength of both companies and to increase brand awareness. So they've agreed to co-branding. So we say, well, that's a binding agreement that they will co-brand. They will use both of the parties' brands. And using the claimant's brand had value to the claimant. because at the end of the 10 years, the claimant's brand will have built along with the defendant's brand together. So there is commercial purpose to this, and it's an agreement that during the term of the partnership, that's what will happen. So we find it quite difficult to understand what that clause can mean if it doesn't mean the parties have to co-brand during the course of the partnership. And what you won't find in Justice French's judgment, with great respect to him and to his judgment, is an explanation of what the clause actually means. And you won't find that in my learned friend's submissions either. And so what we say, and if one goes on through this clause, you'll see the clause says the parties have agreed to conduct an external branding study. And then it says, last sentence, both parties have agreed that the new branding will be implemented not later than 3 months after the closing date. So the effect of that, we say, is that that does not permit a defendant the defendant just to say, I'm going to remove your branding from the enterprise's branding, so it's no longer co-branding. And secondly, we're going to depart from the study which set down the agreed strategy for the term of the partnership. And I think Justice French said, well, this isn't some sort of expert determination, but it doesn't need to be. It just needs to be a mechanism to get to the result which everybody agrees will be implemented. And then he said, well, it's not commercial to tie everybody's hands to one branding strategy for 10 years. But that was never our position. It's obviously open to the parties to agree between themselves to change the branding. The only question is, can one of the parties unilaterally do that? And if it's in the power of the defendant to do it, in the sense that they're in control of the marketing team and the sales team and various other aspects of the business, then all this clause does is to stop them from doing it by themselves and require the parties to come together. Now, I accept entirely that Justice French took a view on this and decided against us. Understand that completely. The very next day, what happened was the defendant gave notice of termination of the contract and notice that they were proceeding with the rebranding. So this is the day after. So there was no point in an appeal against that decision. And on an appeal, the decision would have been considered again by 3 Court of Appeal judges. But no judge is going to give permission to appeal for an academic appeal, which is what it would have been. So the question then, my learned friend says, well, you've got to go back to the judge. We can't. He says, you've got to go up to the Court of Appeal. We couldn't. And so the question is it open to me in a subsequent set of proceedings where I'm not bound by his finding, but the court will have regard to it, no doubt, to suggest to another judge, look, a different judge on a different day, that actually, let's take another look at this and you might agree with me. And we say that if you place the contract into the factual context, because the judge's decision was based on what he understood to be the commercial situation, it was very much rooted not in the language of the contract, but in the facts that as he perceived them on a day, in a short interim hearing, rather than at the end of a trial, where one might take a slightly different view. And this was my point about we take a different view of the nature of the contract. We don't say it's a partnership, but we do in a legal sense. But we do say it's more than just a service providing contract. There's a genuine sort of merging of enterprises going on here, which gives the parties an interest going forward in how the company presents itself to the market. Now, those sorts of facts can be properly investigated at trial. They could not be investigated by Justice French. So we do say there is a prospect of coming to a different conclusion on that. And yeah, I won't labour the point. But the other aspect of it is this: there is a practical point here. So, and it's often one encountered on immediate judgment applications where the court looks at it and says, well, the claim as a whole is open to proceeding. I mean, you can't get rid of the whole claim. Now I'm being asked to carve off a small piece of it. Is that really a sensible way to deal with it procedurally? Because the effect of that is you can end up with 2 tracks. you end up with somebody having to appeal that particular decision and take that upwards, and then another track where the claim proceeds in a different way, and that can lead to procedural complication. And so the question then is as a matter of discretion, because the court, has a discretion as to how closely it looks at these questions and how much of it decides for itself at this stage on an immediate judgment application. And we would say, in the exercise of that, the court should be slow to fragment the process, which is what that likely would do. And ultimately, all of these issues are going to arise anyway. Where does it come in? It comes in on the termination piece, because we say, well, you weren't entitled to do what you were doing, and we came to court to try to stop it in a legitimate way. But B, we genuinely believed you weren't entitled to do what you were doing, and therefore it was legitimate to come to court to try to stop you. Whether we were right or wrong about that, to place that in front of a judge and say the parties can't agree, please make up your mind about it. So at trial, the court is going to have to look at that issue one way or another, if I'm right about there's an arguable prospect on my termination case. So what it's going to be looking at the contract, understanding whether that was a genuine interpretation, how the claimant came to the position to instruct counsel to come to court to argue those points, and whether that in itself constituted some sort of anticipatory breach of contract or created so much damage that the contract had to be brought to an end because it became pointless thereafter. So the trial judge, if it's Your Honour, will be looking very much at these issues and closely connected issues, one way or another, whether this is a live pleading or whether it isn't.
Are you going to deal with the point about the defendant not being able to rely on its own wrong? The point about if, for example, the court were to find that there had been a substantial underpayment of the percentage share under clause 5 of the contract. I'd just like to be clear about how you put your case on repudiatory or renunciatory breach.
Yes.
In the event that there was that finding. Where do things stand? Because if, for example, the two extremes, if the claimant's conduct said to be repudiatory was analysed, it would be open to a court to find that was repudiatory. I'm saying no more than that.
Yes, of course.
How does the fact that a court might also find that going on in the background was this substantial concealment of and underpayment of the share of gross revenue due? How do they fit together, do you say, in the analysis of breach and acceptance of breach?
Yes. All right. So that comes in at the stage of whether or not the termination by the defendant was lawful or unlawful. That's really the key point there. And in deciding that, the court's going to need to look at the grounds advanced by the defendant. And amongst them, it appears to be said, well, we couldn't rely on you going forwards because of the things that you've done in the past. And so we would say two things. Firstly, they are not, as a matter of law, entitled to rely on their own wrongdoing in relation to that. Now, I'll show you this, but my learned friend mentioned the recent UK Supreme Court decision on this, but it doesn't affect anything in the DIFC courts because it's baked into the contract law. The principle is actually written into the law. So we can rely on those sorts of principles where they're reflected in common law courts. But when the principle is actually in the law, we can't rely on the common law courts to say the principle doesn't apply.
Well, well familiar with that. Part of my initial learning in coming to the job, as you will appreciate.
Yes, and there's I'll take you to the relevant provision in the course of those, if I may, rather than going right outside it. Well, I can show you it now. Actually, it's page 3414.
3414.
Yeah, which is inside the contract law. It's Article 78.
Yes.
And you'll see a party may not rely on the non-performance of the other party to the extent that such non-performance was caused by the first party's act or omission, or by another event as to which the first party bears the risk. So that's the prevention principle. And so but more fundamentally, the question is going to be at that stage of the proceedings, is it right that the defendant could not rely? Sorry, I'll let you take your note.
No, it's all right. I've got it.
Is it right that the defendant could not rely on the future performance of the claimant? And to the extent that the defendant is complaining about things that are effectively caused by the defendant's own conduct, then we say, just quite independently of any other legal principle, means that it's not possible for them to say, well, you behaved in this way, if they caused the claimant to behave in that way, and that is the justification for the behavior. So there's two different ways that we come at it on, but I'll pick that up again, if I may, on termination.
For that.
So that I was going to move on now just to deal with this confidential information point. And we do say that this ground is quite remarkable because, and this is morphed and changed quite a bit. What they say in their skeleton, this is paragraph 20, is that the use of confidential information in these proceedings is an abuse of process. So it's an abuse, and there's a breach of confidentiality in two ways. One, by providing the information to the court, and two, by providing the information to a litigation funder. So I'll just deal with that. But just if you go 21.5 is where they say who we've disclosed it to, and why that's, and so foreign litigation funders and their representatives, and relying upon or deploying confidential information in public court proceedings. And just picking up that last point, just thinking that through. I mean, according to the defendant, it's an abuse of process to bring a claim based on confidential information. Even if you're entitled to the information, you can't bring a claim on the basis of it. I mean, that's a startling proposition. You need strong authority for it, and there is none. There are any number of claims before this court and all other courts that involve confidential information. And the way that the court deals with that is not by striking out the claims, but in appropriate cases, applying mechanisms to deal with it. You can have confidentiality rings or closed court proceedings or sealing of the records in an appropriate case. And in fact, this court sets its face against it, rather like the English court does, and asks the question, is this genuinely confidential material that the public can't see? But it's for the party seeking that protection to ask for it. It's not an abuse of process to bring the claim. It's strike out the claim. Showing the information to the court is not an abuse. And similarly, showing the information to advisors, legal advisors, for example, is not an abuse or even a breach of confidence. So, I mean, just imagine where this goes. Assume this is assume for a moment that this is fraudulent underreporting by the defendant of a grand scale. That case is made out. If my learned friend is right, I'm not entitled to make out that case. There's nowhere I can do that because the information is based on confidential information. So there's no way I can vindicate my legal rights. And even if there wasn't fraud, that would still be an astonishing proposition, because virtually every commercial relationship, the claim depends on showing the court something which would be not in the public domain, would be confidential in the sense that it's about business dealings which parties have a legitimate interest in not showing to their competitors. And there is a rather more sinister aspect to this bit of it, though, I have to say. I mean, this is these accusations of hacking which are going on in the Dubai criminal courts. And those are put on the basis that Mr. Fontmante unlawfully accessed the CRM system and extracted the data. That's partly how it is put. It's alleged there. And Mr. Fontmante has been deprived of his passport since those proceedings, since he returned to Dubai to meet those proceedings. He doesn't live in Dubai, and he's been stuck in Dubai ever since. And we do say that is a disgrace. And we will consider, Mr. Fontmante will consider, whether to bring malicious prosecution claim on the back of it, because it is founded on complaints partly made by Mr. Teixeira. Now, in this court, in their application notice, they did say this, and you'll see it at page 78 in the application notice, and it's paragraph 2, subsection 3. They do say the claim relies on information obtained by the claimant unlawfully and in breach of confidence. So that's the first part. And then they go on to say the claimant acted in further breach of confidence by sharing that information with third parties. It's very unclear whether that first part of the sentence is still maintained by my learned friend. He makes no mention of it in his skeleton argument. He makes no mention of it in his oral submissions. You'll see in the skeleton argument, I've shown you it at paragraphs 20 and onwards. He sets out what he says is the problem. But just in case there is a concern in relation to this, I will deal with it because it is important to understand what is going on here. These are allegations that in a commercial court in another jurisdiction might not seem terribly serious, but they are having real world implications on the claimant's officer. The first point is that the claimant was entitled to the information, and you see that we've seen this already. It's page 60. It's of the contract. It's page 22, and it's clause 3 generally. And in particular, I mentioned clause 3.5, which is over the page, which allows the seller to do due diligence in this regard. They're allowed to go in and check. And it's now said by my learned friend for the first time, orally, well, actually, that only applies during the course of the contract. So post-termination, he says the information, the documentation has to go back. He provides no support for that whatsoever. There's nothing in the contract that says anything to that effect. There's not an agreement to license the information, for example. It's just you can have the information. And there's no principle of law to the effect that you have to return the contents of or documents containing confidential information, none that's been identified, and we say none exists. So again, this is just a sort of, what's happened is a serious allegation in the context of the UA is made in an application notice, and it seems to be abandoned. And instead of abandoning it, they retreat to a different set of allegations, which are potentially equally serious, and we have to respond to them. But in any event, as Mr. Teixeira knows full well and admits, Mr. Fontmante was himself provided, and the claimant was provided, with access credentials to use the CRM system by the defendant. And I just want to show you two documents on this, if I may. Page 1243. You'll see an email from Mr. Teixeira, and this is 12th of June, 2020. And if you go down under the heading, he says, "Hi, Oriel, hope this email finds you well." And he's dealing with operations. And you will see under that, if you go down, do you see GSIR CRM access to be given to Oriel on the 14th of June? So he's saying this is what's going to happen. We'll give Oriel, that's Mr. Fontmante, access to the CRM on the 14th of June, and then GSIR emails and CRM access will be created and given to L.l.c team post Sunday meeting. And then later on under finance, all the revenue deals will be recorded under GSIR. And by the way, just so you pick it up for later, there was a proposal that they might be called high-end real estate, HERE. We'll see reference to that in due course. But so then on actually what I don't know whether it happened immediately, but certainly it does happen. 11:03, you then see the email from Kevin Dominguez. At luxhabitat.sar.com, and he emails Mr. Fontmante and copies in Mr. Texera, and he provides, if you look down, email login credentials and CRM login credentials. I think it's a slightly different. Yeah, and there's another set of login credentials I've sent on the same day over the page at 11:04. I think that's slightly different. I don't know why that is the case, but there we are.
Is that the password being sent? He's saying
no.
In the first emails, he says password sent to OF, that's Oriel Font, is it? That looks Habitat. OF, is that Mr. Font's email?
That must be right, yes. Yes.
So
but the next one is, in fact, a different one that's sent to FC. And that's Francisco Cañete. And I can't help you, I'm afraid, who that is.
All right. We're just trying to make sense of documents.
Yeah.
Don't try.
No, quite.
The simple point is he was given access to the system, and here is the proof of it, you say.
Yes. And Mr. Texera admits it. If we go on page 1609.
Yes.
Paragraph 25.
Yes.
He just says, we do accept we sent it. He says that. So he says, appears to rely on the fact that he was provided with access, in September 2020. That is correct. However, that access had only been provided for the limited purpose of allowing the claimants to comply with its obligations under the agreement. There's nothing to that effect. There's no case advanced on that footing by my own friend, at least at this stage. Maybe he'll come up with it later. But so just dealing with its stages then, the allegation that it was obtained unlawfully is false. You're being told things that are untrue. The subsequent use I'll come on to, but the allegation of hacking, obtaining documents by hacking, is simply false. Now, what about use? As to the use in this court, the answer is very straightforward. The parties agreed in the contract that they were entitled to bring claims in the DIFC courts. That's enough. That's at page 54. And it's clause 20 of the contract.
Yes.
And the prior provision is at 19.3, which deals with the after effects of mediation. If you haven't, second line down of 19.3, if no resolution is reached, the aggrieved party can accordingly initiate legal actions as stipulated in clause 20 of this agreement below. So the parties have expressly agreed that they could submit their claims to this court. What does that involve? Obviously, it involves bringing information that would be necessary to support those claims. Now, had the parties wished to preserve confidentiality, they could have agreed to arbitration, but they didn't. The idea that there is a breach of contract and using information that claimant was freely given access to sue the defendant is, we say, plainly wrong. What about legal litigation funders? Well, in bringing this claim, the claimant is so if you're with me so far, the claimant's entitled to bring its claim. It's therefore entitled to do the things that are necessary to bring its claim. And that includes sharing documents with its advisors, the lawyers. What about, my learned friend said at the prior hearing that there's going to need to be expert witnesses in relation to this claim. So is he saying that he's not entitled, and I'm not entitled, to provide the underlying documentation and information to expert witnesses for the purposes of preparing what he says is going to be his defense to the claim? It's absurd in my submission. And so in that context, we say funders are and should be treated like any other litigation advisors or facilitators, people who are assisting in the litigation. Now, there is not a lot of case law in relation to this, but there is one case that we draw Your Honour's attention to, which is the L.l.c case, where Mr. Justice Popperwell, as he was, looked at this in the context of privilege, and you find the relevant passage at page 1980.
Yes, I'm there.
And I'll just draw your attention to paragraph 4. This is subparagraph, sorry, it's Lord Justice Popperwell, I do apologise. This is 195, subparagraph 4. He says it's common for liability insurers to have the conduct of proceedings to which they're assured are parties, but they are not. It would be absurd if litigation privilege attached to communications by the assured for the dominant purpose of gathering evidence and conducting the proceedings, but not to those of the insurers who commonly undertake that function. Other non-parties, such as litigation funders, may play a significant part in the conduct of proceedings. Then goes on to consider a contrary submission. Ms. Oppenheimer suggested that insurers and litigation funders should be treated as equivalent to a party for the purposes of the privilege. Sorry, but the principal basis for doing so can only be because they have an interest in the outcome, in those examples, financial interest. That, however, may be equally true of non-parties to litigation who have no control over it, as the next example illustrates, and goes on to look at other non-parties who have an active role to play. And so what he's saying is that they're obviously an essential part of the business of doing litigation. And so when information is shared between them, it's absurd to suggest that those communications are not privileged. And for the same reason, we would suggest it is absurd to suggest that there's any prohibition on sharing confidential information with people who are essential to that process. Now, it is very unclear what it is being said has been shared. I am not going to sit here and waive privilege over discussions between my client and its litigation funder, and the court's not going to ask me to do that, I'm sure. So my learned friend can go no further than what is in the pleadings. All he can say is, well, you can see what's pleaded, and therefore there must have been, and we know that there's a funder, and therefore that information must have been provided to the funder. But what is in the pleadings is of necessity what is required to put forward this claim. If we're entitled to put it in the pleadings, we're entitled to deploy it for the purposes of putting it in the pleadings. Otherwise, what he's saying, if we're entitled to plead it, if you're with me that far, is that we can't put it in the pleadings and then show those pleadings that have gone into a public court hearing to a third party. It all falls within the right to bring our claim. So there's no breach of confidence, either in obtaining the information or in using the information. But assume I'm wrong about that. Assume there was a problem. There's no abuse of process as a general rule in bringing a claim based on confidential material. And English courts have looked at this evidence obtained by hacking, which is the closest equivalent to effectively what was at least at one stage being alleged. And you have that in the Ras Al-Khaimah case. And I just would like to show you a couple of paragraphs of this, if I may. It's at 2587. Sorry, 2589, I should have. Sorry, 2588. 2588.
Yes.
And they look at the question of whether evidence obtained by hacking should have been excluded. And for your note, I won't go through it all, but you may be instructive for Your Honour to read paragraphs 40 to 51 in due course. But essentially, they considered whether the evidence should have been excluded first, and then whether the claim should have been struck out. And they make the point at 41, cases of torture aside, the general rule is that evidence is admissible if it's relevant to the matter in issue. But they make the point, and they go on, they make the point that the court has a discretion to exclude it. Paragraph 42, citing the Bell Cable Media case, just bringing your attention to this, the common law has always set its face against preventing a party's civil proceedings from adducing admissible evidence, even where it's been improperly obtained. And they refer to paragraph 43. They note the discretion, and 44 they refer to the Jones and University of Warwick case, and then over the page you'll see they say paragraph 45, in the result in that case the balance came down in favour of establishing the truth, and the evidence was found to be properly admissible, and that's ultimately, it's a balancing exercise for the court as to admissibility in those circumstances. And sometimes comes up in the context of privilege. I won't go through all of this, but at 47, it was important in that case that they found that the documents which were alleged to have been hacked would have been disclosable in the proceedings had they been brought. And in the same paragraph here, they make the point, it goes over the page, top of page 2591, 3 lines up from the bottom, the materials revealed serious fraud on the part of Mr. Azim. So that was also important in the balancing exercise. And it was also important that in essence, that was really the only way that he was able to get the evidence. That's paragraph 48. And so they decided, you'll find it later on, that ultimately they dismissed the appeal. They accepted that the evidence was admissible, should not have been excluded, and they refused to strike out the claim. And they do that at paragraph 63. And one of the points they make is otherwise the defendant would have got away with a fraud. And so it's always a balancing exercise. But in that case, where there was clear evidence of actually extracting by hacking, not of refusing to return, then they would not exclude the evidence, they would not strike it out, and they would not have granted an injunction for its return, because it's just going to end up coming back again in the course of an application for disclosure in the proceedings. In their skeleton argument, a couple of other cases are referred to. I don't need to go to them in detail because it wasn't dealt with in detail, but paragraph 22.1 of the skeleton refers to a case where an employee unlawfully takes information from their employer in breach of confidence and will ordinarily be injuncted from relying on the information. That's Pavone. But that is not this case. That's not abuse. There might be grounds for an injunction about use of the information, but the court's obviously going to look in that context at whether or not what the use is going to be, and it's going to be very reluctant to say you can't use it in court proceedings. There are cases where you can't use documents and information without permission in other court proceedings. For example, in a freezing order case, if you get a freezing order with ancillary disclosure obligations, you need permission to use it subsequently. And if you do that in breach of an undertaking or do that in breach of an injunction, then you might be in the realms of abuse. But that's because the court's told you not to do something and you are doing it. But those are very different cases. And paragraph 22.2 of the skeleton fits into that category as well, because it says a litigant who misuses documents subject to undertakings of confidentiality, preventing collateral use, is liable to having their claims struck out. And that is a case when they're talking about undertakings, of court undertakings or implied undertakings imposed by the procedural regime. But again, that's a contempt And so it's not surprising that acting in contempt might be abusive. The third case then that they rely on, 22.3, is the Cengiz decision, and they say this about it. They say it's authority for suggesting that a litigant who misuses confidential information or documents may have their claims struck out or their references to that confidential information excluded in the exercise of the court's discretion. Cengiz is not an authority on abuse of process. You find it at 2908. So it was about divorce proceedings. And you can see this from the head note. But what had happened in that case was that you had divorce proceedings and you had a wife whose brother shared an office with the husband. And essentially he went into the husband's documents and stole information, documents for the use in court proceedings. And the husband sought an injunction for their return. And at 2909, down at the bottom, paragraph 3 of the head note, you can see the outcome. But essentially, the court, this is in the Court of Appeal, the Court of Appeal ordered delivery up of the files and in the end, an injunction restraining the use of the files for now. Now, in their skeleton argument, my learned friends referred to paragraphs 168 to 177, and those start at 2960. And when you read those, as I'm sure you will, you may have already done it, given the footnotes.
Yes, I have read them.
You will find that, contrary to what is said by counsel in their skeleton argument, there is no suggestion there that claims can be struck out because they are based on confidential information. Illegally obtained evidence can be excluded, but the court has set its face against it, as we've seen from the authorities I've shown you. Whereas here, information would be disclosable because it's relevant, that is very unlikely that they're going to exclude it. We saw that from L.l.c. case. And so while in certain cases, and Cengiz was one of them, you might be able to get an injunction restraining you from using the information for now, that is not a general rule. And it's certainly, there's nothing in there to suggest that you strike out a claim in those circumstances. Now, I don't want to invite yet another application in these proceedings before we actually get to the defence, but there is no application for an injunction you have to worry about at this stage. But fundamentally, we say the defendant gave the claimant access, the claimant was entitled to the information and was entitled to make a claim on it. And it's not abusive to bring a claim to vindicate those rights. That leaves immediate judgment in the 6th ground. So I was going to move on to deal with that. Now, ground 1 is really I would characterize it as a pleading point about rectification. As Your Honour is now aware, the issue arises because of the definition of gross revenue, and it refers to monies generated by the seller and other affiliated companies and so on. And our position is that that is an obvious error, and the intention was to refer to the buyer. Now, I'll come on to why we say that in a moment, but the first question is, how does that need to be addressed as a matter of pleading? So the pleading, you'll see at paragraph 7.1. It's, if you're in the bundle, it's 1634. Starts at 7.1, and we set out our position that the reference to seller is a mistake and should refer to buyer. So we set that out. We would suggest clearly it's in the chapeau to 7.1, and we identify the common mistake at 7.1.6. And we set out a number of factors that we rely on in support of that. Now, it is right that the claim form itself and the pleadings did not expressly seek the remedy of rectification. But we say that is unnecessary. And why is it unnecessary? Because the court can deal with these things as a matter of construction. And that is clear from the case of Chartbrook and Persimmon, which I'm sure you've seen many times, but just two short paragraphs of it. 2029. It's paragraph 22. Brightman L.j. stated the conditions for what he called correction of mistakes by construction. Two conditions must be satisfied. First, there must be a clear mistake on the face of the instrument. Secondly, it must be clear what correction ought to be made in order to cure the mistake. If those conditions are satisfied, then the correction is made as a matter of construction. And paragraph 25. What is clear from these cases is that there is not, so to speak, a limit to the amount of red ink or verbal rearrangement or correction which the court has allowed. All that is required is that it should be clear that something has gone wrong with the language, and that it should be clear what a reasonable person would have understood the parties to have meant. In my opinion, both of those requirements are satisfied. So in his skeleton argument, or their skeleton argument, my learned friends say,
just remind me, was there a claim for rectification in Chartbrook?
No, they were dealing with specifically rectification by construction.
Yeah.
So whereas perhaps in the 19th century, these issues of have you actually pleaded the remedy, pleaded a cause of action in rectification, or whatever you want to describe it, the modern way is that actually, if it is clear, if these conditions are satisfied, then you can correct it by construction in the way that you would understand a contract in a normal process of construction. You consider what it might mean, and you do an iterative process of testing each of the different interpretations that might arise. And what this is saying is you're not constrained by the literal words, because if the literal words have to give way, then they will give way. And this is the test for doing that. So so that's why we said we didn't need to put a rectification claim into here, because we say it is sufficiently clear. And what my learned friend says is that there's no mistake, and they say if L.l.c, this is paragraph 25, if L.l.c seeks a judicial correction of that alleged mistake, it can only do so through a properly pleaded claim for rectification. And that's just wrong. But seeking to clear the way and say, look, let's not have an argument about this, we produced the amendment, which, if permitted, would plead out a rectification claim. So you see that at 7.1.6, and the claim was added to the prayer at 7 at the end.
Yes, I've seen it.
And bear in mind, I mean, the defendant's not yet filed a defence, so there's nothing to amend on their side. There's no prejudice to them in relation to this. But even then, they've refused to agree the amendment, so we've had to make the application. So the test on the implication is whether the proposed claim has real prospects of success. And we say that it does. But
the burden being on you, you accept that, I'm sure, to show.
Yes. On an amendment, I mean, what we've got is already a pleaded out claim for rectification by construction.
Yeah.
So if you start from the premise that that's arguable, just bolting on a rectification claim doesn't require a huge burden. But I will take you through why we say it is an obvious error. Now, we say we pleaded enough. Obviously, if Your Honour takes a different view, then we will plead out more if that is what is required. But the modern way with pleadings is that you don't have endless documents pleading out every tiny bit of evidence. You have to take a relatively proportionate approach to these sorts of documents, and you require a reasonable pleading that gives reasonable notice of what the case is that's going to be advanced.
Well, you've given rather more extensive notice, perhaps arguably not in the appropriate place, but in your skeleton argument, you set out in extenso why this is an obvious mistake. They're written down. You're not going to be able to resile from that.
No, quite. And that's the question, is do they have reasonable notice of what the case is going to be? And courts have always accepted that pleadings are not the beginning and the end of it, and that is developed in the evidence and in the arguments. But what the court should not be doing is telling parties that unless you argue your case in the pleadings, I'm going to strike it out, or I'm not going to allow you to advance that case. And courts ebb and flow in their approach to these sorts of things. Some people prefer memorials, and some people prefer English-style pleadings. But this court, in my experience, has always preferred English-style pleadings. Now, that might be right, that might be wrong. And if there's to be a change in that approach, then everybody needs notice of it. And if that's what you prefer in this case, then we will do that. But we say that there's sufficient out there, and we can do it. But let me, if I may say so, take you through why we say this is an obvious error. But just to pick up one further error in my learned friend's skeleton, paragraph 25, he says it's significant. This is the final sentence of paragraph 25. It's relevant to note that the terms of the agreement were drafted by L.l.c. So if they are unclear in any material respect, its interpretation against L.l.c must be preferred. Now, the footnote refers to the contract law. It doesn't refer to any support for that factual assertion. And the factual assertion is not correct. And we've got evidence on that. In fact, it was an external lawyer who was appointed by the parties. So you've got that at page 1074, paragraph 71.
1074. That's a bit of a striking error, if this is right. Who says this?
This is Mr. Fontmante. On the 1st of June 2020, I sent the first draft of the PSA to the defendant. It had been agreed between the parties that the PSA would be prepared by an external lawyer who was in a position to draft it fast, as it is only to contain what was already contained in the MOU. The lawyer's fees were also agreed to be shared equally between the parties. So what's happened is you'll recall that there's an MOU which sets out broadly what the parties intended, and then the parties agree, we'll send that off to the lawyer, we'll both pay for the lawyer, and then the lawyer will do the drafting. So what's happened?
Who instructed the lawyer as a matter of fact of instruction?
Well, it looks like it went across, but I don't know. Hang on. I'm not sure as to precisely who sent them the document, but the agreement was that they would send the MOU, according to this, send the MOU, which was the agreed document, just to the lawyer, not with any additional instructions. It's just going across and everybody's bearing half the cost. Now, one person has to do the sending, otherwise the lawyer gets 2 copies of it, but there's no material distinction between who actually sends the underlying material to the lawyer, and the error comes at the lawyer's stage, as we'll see, because it creeps into the definition of gross revenue, and that is not a definition that you find in the MOU. So what's being said is that this all has to be the drafting of that clause has to be held against my client, but in fact what's happened is they've agreed a lawyer will do it, and the lawyer's got it wrong. Now, that's nobody's fault. But it just, when you look at this, there is no presumption that should be applied, at least against my client, in the construction of this.
One can't help wondering, are we going to, if this matter goes to trial, is said lawyer going to appear? Would his evidence be admissible?
Well, it might be. I mean, it might be, because it's different in the DIFC. And it might turn out to be evidence of the negotiations, which is admissible expressly under DIFC law. But there we are. I mean, I wouldn't necessarily want to be the lawyer being cross-examined, but there we have it. Right.
So you say essentially it's a joint instruction of a lawyer. It's the product of a joint instruction of a lawyer by agreement between the parties.
Yes.
And a sharing of the fees arrangement was put in place.
Yes. So we say that there are a number of reasons why, and I'll just take you through briefly, and you've read my skeleton argument, but just to emphasize some of the points. The first point is that only the buyer was going to...
Shall I go to your skeleton? Are you going to use this as the framework of the submission?
I wasn't going to go through it, so I might go through it in similar order, but yes, I can't remember, I'm afraid, whether I tracked it precisely.
Well, do it as you wish.
I'm grateful.
And if you want to emphasize it by any reference to any paragraph of the skeleton, please do so.
Thank you. I think the first point was that it was only the buyer, that is the defendant, who is going to generate revenue in the sense of actually sending out invoices and receiving cash. So the agreement was that the entire sales team would move across to the defendant. So there was no one left to conclude a deal with the claimant, if I can put it like that. So the agreement was that the defendant would be transacting all of the business with clients. That's it in the contract paragraph preamble C, and then also paragraph 9.4 of the contract. Now, if you think about revenue and what it means to generate revenue, the revenue we're largely talking about here is going to be commission. And so the question is there any meaningful way in which you can say that that revenue is generated by the claimant, but not by the defendant? I can put it like that. And we say that there isn't. Just looking at the contract, and so those who don't have it printed out as PEP are now at page 46. Am I? Should be at page 45. Yes. Now, sorry, it is page 46. There isn't the term that is used in relation to the fees, and you see this at I, is combined gross revenue. And you immediately see that something's gone wrong there if that is a revenue potentially going wrong, or slightly loose at least, combined gross revenue, if we're just talking about claimant generated, if I can put it like that, revenue. Because combined gross revenue makes sense if gross revenue is talking about all of the revenue essentially received from the business by the defendant, because both parties contribute to that. But combined gross revenue doesn't make sense if you're talking about some subsection of that which has only been generated by the claimant, because then you're saying, well, that's claimant generated, it's not combined, it's just the claimant. So it does make sense on our construction to use combined, but doesn't make sense on the defendants. Now, the phrase is also used in relation to the payment of the upfront fee, and we see that on page 44, and this is clause 4.1c, and you'll recall this, the staged payments under the seller note. Yes. And you'll see that 1 refers to the combined joint revenue of the parties. So but before that, it says the contractual payment, this is in C, 4 lines down, the contractual payment at the end of the first, second and third year to commence from the closing date, and will be based on the overall business of the parties, which most importantly will include Gulf Sotheby's and Lux Habitat, and then sets out what is meant by being based on the overall businesses of the parties, and refers to subparagraph 1, the combined gross revenue per year of the parties. Now, my learned friend relies on this in his oral submissions to say, well, this is different because this clause says the combined gross revenue of the parties, whereas the clause 5.1 refers to the combined gross revenue. But if one just thinks that through, even on his case, something's gone wrong with the definition, because the definition on his case is that gross revenue is only revenue generated by the defendant. So how can it be combined gross revenue of the parties? Because then what you're saying is gross revenue of the defendant, but of the parties. And it doesn't make any sense. In other words, it's another factor which points you to the conclusion that when it's talking about gross revenue in each stage, it's talking about everything that's received by the overall business, which in practical terms is what's received by the defendant. So the clause on his construction can't work, and of the parties just makes it more unlikely that he's right. And the clause obviously sets, so if we go back to 4.1, we're still in, this sets the thresholds again, which are at this stage at least similar thresholds to those being set subsequently in relation to the partnership fee. We do say that the third point is the mechanics for monitoring performance are consistent with this approach because they didn't try to attribute responsibility for a sale. They tried to measure performance by reference to lead generation. Now it can be possible to identify a lead generation. In other words, where was the first interaction with this specific customer? It's difficult and it needs to be tracked, but ultimately it still requires all of the parts of the process to conclude a deal. You still need an agent to do the deal. And so there was no mechanism for trying to work out who actually was generating in some way of, in other words, entitled to take credit for the fee commission itself. And I made this point already to you earlier, but we do say if one looks at 5.1K, you'll see it says the KPIs, starts talking about KPIs at K. The KPIs will analyze the performance of the partnership, and the automatic renewal of the partnership after the first 5 years will be subject to, and then 1, the business being amongst the top 3 positions in terms of website traffic within the real estate brokerage industry in the UAE. This will be measured using external third-party providers. And 2, the online direct channels should be the first lead generation source of the business during the 5th year, and then the methodology will be agreed, the methodology to measure that. So as I mentioned, the partnership fee needs to be capable of calculation from day 1, but that would be impossible if it was about lead generation in circumstances where the parties haven't agreed a mechanism for determining lead generation, let alone a mechanism for determining who contributed what to each individual sale. So we say this all shows that the fee calculation was not based on an assessment of the claimant's contribution or by reference to the claimant's sales agents, if that be the case. And these provisions are about KPI monitoring. They're about performance monitoring for that 5-year break. And you were taken, as I say, to M, and that does talk about revenues by channel, but it is still talking about leads, the number of leads per channel, cost per lead and channel, and also transactions and revenues generated from each channel. So it is not talking about the contribution of the seller being that, and that being the definition in effect, as my friend says it is, of gross revenue.
What does channel refer to in this clause, do you say?
I think it's referring to, by reference to websites, social media, and various other defined sources of contact with clients. So my point is that in circumstances where the parties are still to agree an effective mechanism to determine where leads are coming from, offline and online lead tracking systems, that's at K2, then this is going no further than saying that once that is available, once that process is available, then we're going to keep track of it. We're going to look at that and say, where are the leads coming from, and what is the revenue that's associated with that, with leads from that channel.
So
that's sorry.
So, I'm sorry to interrupt you. I just want to be clear about what you're saying here. So K, subparagraph K, is to do with KPIs for the purposes of the 5-year break, but M has a wider purpose for monitoring basically what works. Isn't that right? What works in terms of how the business utilizes the various channels, assuming your understanding is correct, to generate business.
Essentially, yes. But the point is that it's all about doing that by reference to leads. And therefore, if the answer is we haven't got a defined system to determine that yet, then yes, we're going to do this going forward because that's what a sensible business will do. And you have to share that information with me so we can work out what is working, as you say. It is not a mechanism that from day one can be used to say, well, this is revenue that's been generated by the seller, and this is revenue that hasn't been generated by the seller, it's been generated by the defendant. So this is all about monitoring performance for different purposes, for legitimate business purposes, for KPI purposes. But it's not tied to the gross revenue calculation in any way. The fourth point that we make is that there is another term of the contract which supports our construction, and Your Honour is on to us on this point, I think, but the way it was dealt with in orally only dealt with part of what we say about this, and this is the point about Schedule 1. So Schedule 1 arises because if you look at 9.3 of the contract on page 50 of the bundle,
yes,
it says the buyer should be entitled to receive all revenue from future deals unless specified otherwise in Schedule 1. So what they're doing is they're carving out certain deals from the revenue that's coming in, and then Schedule 1 is at page 55 of the bundle, those following along, and you'll see paragraph 1 identifies, it says investment transactions, so it's dealing with investment transactions, and it says the seller has communicated to the buyer that it has 2 investment transactions which are signed with a deposit paid and have also been accounted but have not been transferred yet. Now, my own friend accepts that those were in fact the buyer's transactions. And so what we say is, on a natural reading of that, it's got seller and buyer mixed up because it said the seller has communicated to the buyer that it has 2 investment transactions. The only way to make that consistent with my own friend's case is to say that what it's saying is the seller is telling the buyer, the claimant is telling the defendant that the defendant has investment transactions which are signed with a deposit paid. But there'll be no, that makes no sense, because if they're the defendant's transactions, the defendant's going to know about those transactions and will be informing the claimant about them. So that's why we say that that language must have gone backwards, because it must be the buyer, the defendant, telling the seller about its investment transactions. But that's not the only point here. The point is also, if one looks at clause 1.2a,
there's no issue, is there, that these identified transactions are the buyer's transactions, which it's excluding, as it were, from the deal going forward?
That these are the buyer's transactions. There shouldn't be an issue. There's evidence on my favour, that's in Mr. Fontmante's witness statement at paragraph 68. You'll find that at page 1073. So he says it. So if there's an issue about it, it's a factual one. I thought my learned friend accepted that it was there.
Well, that's why I'm asking. He'll clarify in reply if there is any
Yes.
issue there, I'm sure.
I think what he said is, well, there's still a way of making the language consistent. But as I
Yes.
say, the only way of making the language consistent is to assume that the claimant is telling the buyer about the buyer's transactions, which would make no sense. But there's another point here. 1.2a refers to two particular investment transactions. So it's the Skyview Hotel Dubai by Emaar and the Sofitel staff accommodation. And then 1.2b says the seller agrees that both transactions mentioned above will not be part of the gross revenue calculation, as long as they've been signed, accounted, and with a deposit paid. And then 1.2c clarifies the gross revenue calculation. For the avoidance of doubt, the parties have also agreed that in the future, any other investment transactions done by any of the team members of the parties will be part of the gross revenue calculation. So that's for the avoidance of doubt. That's not changing or amending the definition of gross revenue. What it's saying is what it's saying is that revenue generated, however generated, in relation to these transactions will fall within gross revenue, except for these two particular transactions, which will be removed from gross revenue.
And whose transactions were these?
These are the same transactions.
Ah, the same transactions.
Yeah, clause 1.1 says the sellers, so this is about the two investment transactions. So we know what the transactions are. They are the ones in 1.2a, and then
I'm sorry I interrupted you. It's absolutely clear what they are. Yes.
Thank you.
Yes. Right.
All right. So what that is therefore saying is all investment transactions, apart from these two excluded ones, fall within gross revenue. And so it's not saying, of course, subject to, it being generated by the claimant. So you in this document, this one document, you've got both the same mistake, the swapping of the seller and the buyer, and also confirmation of at least part of the gross revenue calculation being on the basis that we suggest. And it's for the avoidance of doubt that is put in there, not to change anything, but to spell it out. So we say that assists quite considerably, and it just makes it very difficult to see how it can be suggested that there's some other mechanism for assessing the claimant's contribution. The fifth point is that when one looks at what the parties expected the contract to do, the thresholds for the minimum fee were similar to the parties' expectations of the revenue for the business as a whole. So you know by now how the clause works, above a certain threshold of revenue. So that reflects the expectations of the parties of the performance of the business as a whole. So if one goes to 1154, for example, you've got an email from Mr. Azar dated 20th of January 2019, and that has a letter of intent on the next page at 1155. And you see at paragraph 2, Mr. Azar saying, second line, we are looking at dispersing 3% every year as a royalty on our overall businesses, including Gulf Sotheby's, SPF Realty, and L.l.c Habitat. We are forecasting a total revenue of the three entities to be around 40 million per year. So this is strong evidence that although the percentage subsequently changes in negotiation, this is the structure of the discussion that's being undertaken. And that it's all about the total overall business. The sixth point is about the tracking of performance and the obligations to on the defendant to provide to the claimant revenue statements and so forth. I've made the point, I won't labour it, because you asked the point, well, why would they be providing all this information if it wasn't for this purpose? Answer, well, so that they can figure out the stage payments, but the stage payments run out after 3 years, and the clause itself says it's for the whole of the term of the contract, for the whole 10 years. So why, for the next 7 years, are they providing this information if not for this purpose? There's no reason. And then the 7th point is, you can see it in pre-contractual negotiations. Pre-contractual negotiations are relevant to construction under DIFC law. You see that in the contract law. You've been shown it, I think, but it's at page 3407. Clause Article 51A. And interpretation arises under 49, start there. Contracts interpreted according to the common intention of the parties. So already it's quite a distance from the English common law on that basis. And as you will probably know, this is based on unidroit principles, not on the English common law, but there are common law principles introduced in certain places. But in any event, you are clearly at 51A entitled to look to preliminary negotiations, and clearly in 51C entitled to look to post-contractual conduct. In terms of that, you've got the MOU. You've seen this at one stage, but I'll just show you very briefly what we say about it. It's 413. And at 414, you've got firstly the provisions about the consideration, and you'll see that says D, that 4 lines down, it'll be based on the overall businesses, including Gulf Sotheby's and Lux Habitats. And then 1, if the gross revenue per year of the combined companies is more than 32 million, and so forth. And then at 4, so it's very similar to the language that you find in the contract. And then at 415, you've got the language of the in relation to the partnership fees at G. And you'll see that it is combined gross revenue, not capitalized.
Sorry, which subparagraph are you referring to?
Subparagraph G. Is what the MOU said about the partnership fee, the highest of 2 million. So it's page 415.
Yes, I've got it.
So gross revenue and combined gross revenue are not defined. They're just used equally in, well, it said the gross revenue of the combined companies is what's used in the first one, and then combined gross revenue is used in the second one. There's no attempt to define those. There's no attempt to distinguish any parts of the revenue which can be attributed to the claimant's efforts. And so what we say has happened is that an overzealous draftsman has said, well, we better define gross revenue, and has just made a mistake in doing that. There's no suggestion that there was a specific negotiation, for example, of that term, gross revenue, or that definition, gross revenue. There are some other discussions that we draw your attention to that are also relevant. I've shown you the letter of intent at 1155. We say that it's quite clear the intention there was to calculate by reference to the overall business. There's also, if one goes to 1168, you'll see there at the bottom an email from Mr. Azar. This is 26th of December 2019. You'll see Merry Christmas, Oriel. Reviewed the offer. Here's what we can offer. And then you've got A is the upfront fee, but then B, a minimum of 1.2 million dirhams paid for all the marketing services, capped to 35 million gross in revenues, and anything over 35 million in revenues, we will pay 5% of royalty on the gross income of the company. So it's not suggesting there's any division amongst that. 1171, you've got 13th of January 2020. This is from Mr. Azar. If you look down at the 4th large paragraph, your marketing income will be a minimum of 1.2 million a year for anything we make up to 36 million or below. It equates to a 3.5% override on the business, which I believe is fair, and you are not taking any downside risk below 36 million. We only need to agree on certain KPIs and target from marketing perspective. I'm sure your marketing costs cannot be 1.2 million, which means that you will be making money on this regardless of our revenues. And if we perform over 36 million, then your override will increase from 3.5% to 5% on the added revenues of our merger. And then 1183, you've got an email chain there. And just to orient you in it, you've got various people contribute to the chain in different colours. So you'll see Mr. George Azar, and I'm going to show you some of those things that they say. But Mr. George Azar, top left of 1183, is commenting in red. At the bottom, you'll see Mr. Mante commenting in blue. So we can look at what they say. If we go to 1184, paragraph 1, clause 1c, this is the original proposal which is then commented on. Do you see that? It's about a third of the way down the page.
Who's in blue and who's in red?
So in blue is Mr. Fontmante.
Fontmante. Yes.
So that's claimant. And in red is Mr. Azar.
Azar, yeah.
And they're added in that sequence. So the original proposal is in black text. You'll see that clause 1c. And what's said is we will need to add to the clause that the gross revenue will be based only on residential business vertical. And what you see in blue is Mr. Fontmante pushing back. I don't understand this, and argues about it. Our tech marketing platform will not discriminate, blah, blah, blah. And then the response comes back from Mr. Azar. Everything is included except investments, as we do sale lease back on many sectors and so forth. And you'll recall Schedule 1 ultimately records what they're going to do about investments. And they're all included except for some projects. So everything is included. Again, there's no suggestion in these discussions that it's some sort of division up of who's responsible for what. 1209 is the next one. You will see there an email from Mr. Font this time, going back to Mr. Texera and Mr. Azar. And he says in it, considering the deal is linked to future performance of HERE, you'll recall I brought your attention to the fact that at one stage it was suggested they would proceed under the name high-end real estate. So that's why it's HERE. So that's reference to the defendant. Considering the deal is linked to the future performance of the defendant as well, please send us profit or loss, transaction statements, commission breakdown for each deal. So again, you have a clear indication that it was expressed by the claimant that the understanding was it's on the basis of overall revenue. You have
the high-end real estate. When was that put aside?
I don't know, I'm afraid. I can try and find out for you, but I don't know when that went to one side.
It's just that I've seen it somewhere else, and I can't remember where in the correspondence I've read. So
you may have seen it 1212,
possibly, but don't trouble.
Which was a draft. There was a draft of the agreement that was L.l.c, and then it had high-end real estate written there. So you see it 1212, but that seems to have gone, I think, in the contract itself. I believe that's right. It must have been.
It's not important. It's just for my own tracking of.
Yes, understood.
Contractual negotiations.
Yeah, but
so
I think
to look at the email below, the response back, presumably. Oh, that's.
Oh no, I'm sorry. It was actually in the agreement. I do apologise. So if you look at the front page of the agreement, the buyer is referred to as high-end real estate.
Yeah.
So it is referred to as that, but there's no doubt that it is. As to when the name changed, I would assume that was part of the process of the branding.
Right.
But that's a guess, I'm afraid. So I don't have that detail for you precisely when the defendant changed its outlook in that regard. More generally, and we don't have time to look through it at all, 1066 you will find Mr. Fontmante's account of the negotiations, and that runs from paragraph 48 to 71. And in particular, he makes the points largely that I've made, but gives more colour to the context. In particular, he notes the price reduced substantially in exchange for what he described as royalties. If one goes down to paragraph 50, he does give evidence that this was hard negotiated, and he talks about, for example, needing information about defendants' financials because the proposed structure of the deal would involve not just a purchase price but a form of royalties. And he explains that it was always understood to be calculated by reference to all of the business being done. Now, that sort of explanation, of course, is inevitably fact sensitive, because his impression of what the other side thought in that negotiation will come from lots of different places. And so that is an investigation which is inherently one that needs to go to trial. He explains, we say, why everyone knew that it was a percent of the gross revenue of the combined businesses. Now, it's said that that's commercially absurd. Of course, you cannot decide that at this stage. Our case is it's not. It's the result. The large numbers that come out of this percentage are simply the result of the explosion of the property market. It wasn't anticipated, and you can actually see that in the projections that the parties anticipated. The eighth point is that post-contractual conduct is also relevant. That you've seen it in Article 51C of the contract law. My learned friend says that the entire agreement clause cuts across all of these points about interpretation. That is a new point raised for the first time orally. It is wrong. Even as a matter of English law, entire agreement clauses do not prevent the use of extrinsic evidence on either rectification or interpretation. There's plenty of authority on that as a proposition. If it's said that that is English law, it's wrong. And we would have provided you with that authority if we'd had notice of it. But the sort of cases that are known about, cases like Surgicraft, cases like the NHS Commissioning Board, the point is a term that says all the terms are in the document, which is essentially what an entire agreement clause does, can't be read as meaning all the terms are in the document, even in the form that is wrong, when the form is wrong. Now, what I've just said is literally reciting from you a passage from one of the judgments as to but the other way of putting it is that an entire agreement clause excludes the introduction of additional terms. It doesn't exclude evidence of what the terms mean when one comes to interpretation. So we can look, both as a matter of interpretation, as a matter of rectification, at what everybody did to understand what they understood. And what happened was, we say, when the defendant came to pay variable partnership fees, it did so ostensibly on the basis of all of its revenue, not by trying to divide it up in any way. And I won't go back over that material, but give me 1 second. Again, Mr. Fontmanti does deal with this in his evidence at page 1075 as well. And you will see paragraph 73, he refers to what we would say is a clear acknowledgement by the defendant that the contract was intended to respond to the defendant's revenue. For example, this year we would have achieved almost 45 to 47 million, potentially on a year-on-year with you, which covers the 2 million and potentially an additional 250k more as per our contract. And when one unpacks that, they're saying we would have achieved those sums on a year-on-year, which covers the 2 million. So they're talking about what the defendant has done to cause the 2 million and the variable amounts, some variable amount to be incurred. So we say that's an email from May 2021. Yes, it's post-contractual, but it shows what everybody has always known, which is how this contract's intended to operate. And then 75, again, when he reports the results in June 2021, you'll see what's the amount we should expect as of yesterday was the first anniversary. And the response comes back, sorry, on the 16th of June. As for the amount, good news. We've achieved over 35 million, so you are entitled for the 2 million payment of the purchase price. So again, it's linking, that's for the purchase price, that's true. But again, they're dealing with these monitors or calculations of what revenue is relevant in exactly the same way, in a relatively informal way that's just gone wrong when someone's tried to tighten the drafting in the contract. There were negotiations to increase the percentage. There's some evidence on page 1076 about that at the top. And this is an email, it's just reciting an email. I'm not sure who that comes from, but it comes from the defendant. We're looking at the figures and we're asked, we are okay to do 3 million from July 2021 to the end of June 2022, and then go to 2.4 million from there onwards. So these are negotiations of the amendment.
Where are you reading? I've lost you.
Sorry, top of page 1076.
1076. Yes.
So we're still in Mr. Fontmante's witness statement. So what's been said is we're looking at the figures, and you'll recall that the minimum fee reduces in the amendment, and then he says, as for the variable above 40 million for 10%, we've broken down our costing from the 100% revenue, including agent splits, override, royalty, and running cost, and the company net profit does not exceed 23%. So we cannot surely pay almost half of our income in variable. The 5% is already high in view of percentage, especially if next year is not as good as this year, then the fixed cost eats out of the profit. I truly believe 5% is very fair. So let's move ahead and share with us the scope of work so I get board okay before the end of the month.
So the claimant was seeking 10% in this post-contractual negotiation for a variation, and the defendant pushes back and says 5% is already high and is very fair. Let's move ahead and share with us the scope of the work. So on. Is that right?
Exactly. And what they're set, but why are they saying it's very fair? Because it's almost half of our profit. And they're saying it eats out of our profit. The running cost of the company net profit does not exceed 23%. So we can't surely pay almost half of our income in variable. The 5% is all. So it's quite clear. Again, when you place this in context, that what they're talking about is 5% of their overall income, not some subsection of that, because he's talking about it as our income.
After the running cost of the company, he's talking about net profit does not exceed 23%. So he's saying we're not paying you 10% because that's nearly half. But what in fact, what they're paying is 5%, which is just less than 25% of the 23% net profit, and that he contends is very fair. That's
exactly. But because he said that's half our profit, you know what he's doing is he's looking at his revenue, that is the defendant's revenue, and carving it out of that. Now, the defendants made various arguments in their evidence about this issue. Some of them just don't appear in the skeleton.
Sorry, just before you go there, I'm in the habit of taking a mid-afternoon break, as it is in Dubai. So I'll take a 15-minute break when convenient to you in the near future. When is convenient?
If you give me 3 or 4 minutes, I can probably finish up on this immediate judgment application part 1.
Evidence in response, I think, to this.
Sorry?
You were going to the evidence in response, I think, to this, were you?
Well, I mean, I wasn't necessarily going to take you there, but I think what's said against me is there's no arguable case for rectification, whether you do it by construction or whether you do it by rectification. Now we say that I've shown you not everything that will be available at trial, but quite a lot of it, and we say there is a real prospect of establishing that everybody knew that this performance fee was to be decided by reference to the defendant's revenues, if I can put it like that. And so we say there is therefore a real prospect that the response that comes back has now morphed into something more of a pleading point rather than a debate about the merits of the claim. So, for example, you were told that we hadn't pleaded a common intention. What the common intention was, that's not right. We pleaded that at paragraph 7.1.6. It's in there. The common intention was that seller should say buyer. It says it in terms. But the next suggestion that was made orally was that what we should have done was apply for rectification first, get rectification, then demand the full fees, and then claim those fees going forward. But rectification is retrospective. We know that from the legislation, even if we didn't know it from the general law. You see it in the Law of Damages and Remedies at page 3547. And it's Article 41b5 at the top of the page. Retrospective, it has retrospective effect. But anyway, the suggestion that we do it in stages, A, it rather undermines the abuse argument, but B, it depends on what they knew. And we say this is so obvious, and they clearly knew that that's what it was. And so it doesn't actually affect anything in terms of how we put it to them. And the complaint waxed and waned. Partly it was seemed to me to be about termination, because partly they were saying, well, you shouldn't just arrive and announce that we've defrauded you. But all of that rather because, and part of it was put on the basis that, well, if you're rectifying, how could we possibly know that that's what the contract meant? But that's all a factual inquiry into what they did know, what they did understand about this contract, and all of this. So it goes to the Article 40 subsection 2 points as well. But just purely on this point about, is there a real prospect on rectification? It doesn't, that particular argument doesn't work. There's no rule that you have to go to court first to get rectification and only then claim your rights on the rectified contract. And that's never how it works. And then it said we haven't pleaded out the other elements of rectification. And we say we have, and the pleading is at 1635, but paragraph 7.1.1 to 7.1.5. We do not plead out each and every piece of evidence. Now, as I said, we don't think that parties should be expected to do that. But if you would like us to put in more, we will put in more. And what we've tried to do is be pragmatic about this. We tried to take this off the table because they said, oh, well, you haven't, they were taking a technical point as we understood it. You haven't claimed rectification, therefore it's not possible. And they maintained that in the skeleton, and that's just wrong. We said, well, it's so obvious you can do it by construction. But to put this point to bed, we will plead out a rectification claim. So we did it. And then we're told, no, you still haven't done enough. And we, at that point, our position is they're simply being obtuse. But if we're wrong about that, then the answer is that you can tell us there is enough here to plead a rectification claim, so that there's not going to be summary judgment, but you can order us or permit us to put in further particulars if that's what you want. Normally, you'd expect to do it by an RFI.
Well, I was just going to raise that question. It's always open to ask for further information.
All right. That was all I was going to say in relation to the first ground of immediate judgment. In terms of where that leaves me, I'll if I can report back after we've taken the break. I'll tell you how much time we need. Thank you.
Take your time. We'll have 15 minutes now, and we'll resume at 12:30 UK, which will be 16:30 Dubai. Yes, all present and
Thank you.
correct.
Just to pick up one point which came up in my last set of submissions, which was the point about the 2 investment properties in the Schedule 1, just to show you the evidence on this, because actually there's a potentially a conflict of evidence anyway. Page 97 is Mr. Texera's statement on this, and this is where the story begins. At the top left, paragraph 43.2, he is making his case as to why his interpretation of the contract is right. And what he says is Schedule 1, for example, referred to certain of the claimant's transactions, which were to affect the levels of gross revenue. Clause 1.2b of Schedule 1 expressly stated that the seller agrees that both transactions mentioned above will not be part of the gross revenue calculation. So he was there saying, taking it at least at face value, that was accurate, and those were the claimant's transactions. The response to that evidence is at page 1072, paragraph 66.
172.
Yeah, 1072.
Sorry, 1072. Paragraph
66.
Yes.
And this is Mr. Fontmante's response. The defendant then requested to exclude 2 investment transactions from the gross revenue for the purposes of calculating the partnership fees. These are referenced at paragraph 43.2 I've just shown you as being the claimant's transactions excluded from the gross revenue calculation over the page. This is incorrect. They were the defendant's transactions, and the defendant requested that they not be included. And then he sets out the correspondence in relation to that. The relevant email is at 1187.
Yes.
And at the top of that page, you can see an email from George Azar, dated 11th of May 2020. And he says, Dear Oriel, here is the final and signed document. I added the 2 investment transactions we had discussed, which are not signed already, but due to transfer. Also, I reckon that all the way, and so on. So there, on its face, there may be a dispute of fact about whether those 2 transactions were introduced by the claimant or by the defendant. We would say that in light of that email, it's rather difficult for Mr. Texera to maintain the position that those were the claimants, because you've got an email from Mr. Azar saying he added them. But all of that is factual and not to be determined now in any event. But one can see how this could affect the interpretation quite significantly, an issue of fact, because he was saying, Mr. Texera was saying, well, because they're the claimants, that demonstrates that we're talking about the claimant's gross revenue, and that's what gross revenue means. But if he's wrong about the factual premise, as we say he is, and this document appears to show, the logic of his point goes completely the other way and undermines entirely the case that he's advancing. And that shows how you can have factual disputes which can affect the meaning of a contract like this. So I just wanted to clear that up. Also, the other point was the question about high-end real estate. That was never the brand, and I got that wrong, I'm so sorry. That was the name of the defendant at the time of contracting. I think the defendant's name has changed. The brand, though, was initially Gulf Sotheby's International Realty, but changed after the agreement to Lux Habitat Sotheby's International, and then the rebranding came subsequently. So apologies for the confusion there. I said I'd give you a report. I'm hoping to get done in about an hour and 15 minutes, if you'll indulge me. That will give my learned friend a little bit of time to reply, but it's less time than he took yesterday. Ground 2 then, fiduciary duties. We do say that the defendant was the claimant's fiduciary for the purposes of reporting its financial results. Now, what is the relevance of this? It's, in a way, doesn't matter whether you characterize the relationship as fiduciary or not, but essentially what matters is that the nature of the relationship was such that we were entitled to trust them to give us accurate results. And so it could affect the multiple damages claim, it could affect whether these breaches which we allege were egregious, deliberate, and so forth. And the point here is that the defendant was entrusted with the job of accurately reporting the revenues. And it has now sought to restrict the defendant's ability to check that information. But because it was given that position of trust, then that is something which could lead the court to conclude that it was a fiduciary for that purpose. The relevant provision is the Law of Obligations, Article 158. You'll find that at 3618. And the test is in 1581. A person undertakes to act for another in circumstances which give rise to a relationship of trust and confidence. And 152 sets out presumptively fiduciary relationships, but then 1583 sets out that in all other cases, it's a question of fact. Now, we set out the basis on which we plead this in our particulars of claim, and you'll see it at paragraph 7.2. If you've got that in front of you, it's the original particulars of claim for those following is page 22. But the centerpiece of it really, I mean, it is 7.2.4. As you alighted on my learned friend's submission, the claimant entrusted the defendant with the job of recording and reporting revenue. The claimant had access to the CRM, but not to the defendant's accounting information. There was no physical proximity. And in truth, the mechanism and the agreement was that the defendant would report these things, and the claimant would rely on that to calculate its fees. And it was, so the defendant was doing a job for the claimant because it was reporting to the claimant for the claimant's benefit so that fees could be calculated on my case. And in doing so, in making that report, it was in a position of conflict, necessarily. Why? Because the higher the revenues it reports, the more it has to pay. So the worse for it and the more for the claimant. Now, you were taken to the Huobi case in the DIFC Court of Appeal. And if you go to that 3255, I just wanted to show you paragraph 242. So this is 3255.
242.
242. This is where the judge is dealing with, Court of Appeal is dealing with the question of whether there was a fiduciary relationship. One of the things that was missing in that case, if you look 4 lines down, there was no inherent conflict between the interests of Tabarak and Huobi, in respect of which it was necessary to impose a fiduciary duty in order to protect. And that cuts to the heart of it to some extent. If there is a conflict of interest or a potential conflict, then it may be necessary in circumstances to impose a duty to protect that. Well, inference says, well, the defendant wasn't managing the claimant's affairs, wasn't making discretionary decisions on behalf of the claimant. Of course, that's true generally, but it did have authority to, in relation to the reporting, to make decisions which affected the claimant's income. Because if there was a debate about whether a particular sale fell within the gross revenue that needed to be reported or not, the defendant is the one making those decisions in excluding revenue from the reports. And clearly we would say on the facts, revenue has been excluded from the reports because you've got the CRMs, you've got the reports, and they don't match. So if someone is making a decision there as to what gets included and what does not get included, and that is a decision which is entrusted to the defendant. You were also taken to the TMO and Spectrum case. I just wanted to show you a very short passage in that. 3337, please.
Yes.
Just to note the dicta in Arklow at B. The concept encaptures a situation where one person is in a relationship with another, which gives rise to a legitimate expectation which equity will recognise that the fiduciary will not utilise his or her position in such a way which is adverse to the interests of the principal. So they're not going to. So if one takes our situation on the facts, would one say that the defendant, in relation to this reporting obligation, is in a position where they can be expected not to make decisions in relation to what gets reported, just purely in their own self-interest? And if one goes over the page 3338 now down to 9, talking about joint ventures, fiduciary duties may in particular be found to arise where one party has control of assets which are to be exploited for the joint benefit of both. And one might say equally true where one party has effective control over things which will determine the other's income. Over the page, subparagraph 10, second line, the nature of the fiduciary obligations owed is itself a fact-sensitive inquiry to be determined by considering the particular relationship between the parties. And it can affect, it goes on to say, only part of the relationship.
Sorry, what does it say?
So
As a part of
you
the
see, for example, in Ross River, do you see that 3 lines up from the bottom? In Ross River, Morgan J had found that the defendants owed fiduciary duties in certain respects, but not others. And the Court of Appeal found that duties were more extensive. So we say it's a fact sensitive. It can affect part of the relationship. So it's wrong to look at the whole of the contract and ask whether the defendant was in all respects a fiduciary. The question is, was it a fiduciary in this limited respect of producing and reporting information about revenues? And there's only one party doing that, which was the defendant, and they're doing it for the claimant. So the argument that, well, it's completely incoherent to suggest that they could both be fiduciaries doesn't work. It's much more granular than that. You have to look at what are the specific obligations being identified, and are those fiduciary in nature? Ultimately, this is an issue of fact, and all the facts will be pleaded and examined in the proceedings. It doesn't add a lot, or doesn't help a lot, to carve this out of the proceedings for the same reasons that I mentioned in relation to the other point that we were discussing on abuse and strikeout. We're going to have to look at all of this. We're going to have to look at the nature of the relationship and whether or not it was egregious to breach it, given the nature of the obligation, and whether we characterize that as a fiduciary duty or not. We'll need to do that exercise. So we would say there is a real prospect. If you're against me completely and you think it needs to come out, then it only affects 7.2 of the pleading. That's ground 2. Ground 3 is in relation to prime realty. And I've shown you why we say prime realty is an affiliated company and how it's pleaded. I won't go back to that. But essentially, our primary case has been incorporated, it appears, to receive income. We don't know how much, which would otherwise have been received by the defendant. And it's got the same employees and so forth. And it's not presenting itself independently to the market as a broker. So you don't go to the offices of Prime Realty, rely on their marketing, and say, I want a prime realtor broker, or I'm Prime Realty is advertising this property. You go to SIR Sotheby's or Sotheby's, or the defendant, as it now is in its new form, and you say, oh, I see that on your website, and they give you a broker who identifies themselves as a defendant employee, not as a prime employee, and then they say, oh, by the way, actually, when you pay the commission, you need to pay it to this service company or this other company. Is that revenue generated by the defendant, or is that genuinely revenue generated by Prime? And if we get to that stage, is Prime an affiliate? So it's really very much a subsidiary point, which comes after those points. Is this just defendant doing business? Is this the defendant's employees doing business? Those come first. The defendant's case is that affiliated company should be interpreted as meaning subsidiary. That's what they say in their skeleton at the top of page 20. And there are some problems with that, we say. The first is that is not what the contract says, because if you look at the actual term, getting into the language of this, it's on page 40 of the bundle. Gross revenue refers to sorry, it's page 2 of the contract itself.
Yes.
Gross revenue is the total amount of money generated per year by the seller and any other affiliated companies, subsidiaries, or employees prior to deductions. So affiliated companies, other affiliated companies, is used in contradistinction to the word subsidiaries. If affiliated companies means subsidiaries, then what it's saying is any other subsidiaries, or employees. So my learned friend is defining the phrase out of existence. And related to that, as he pointed out, clause 1.2 does define what, not the word subsidiaries as such, but what is to count as a subsidiary. So effectively defines subsidiaries. So that some thought does appear to have been given to what was meant by subsidiaries. And if they wanted affiliated companies to mean the same thing, it would have said subsidiaries.
Or added in company as a subsidiary or affiliate of in 1.2.
Yes.
Join them in the definition. Joined affiliate in the definition.
But if you did that, you'd probably take it out of the definition of gross revenue anyway. And the point I'm making, I think, is that it can't mean subsidiaries because then it means nothing.
So what does it mean?
Well, so we say that, let me start with how it works. I mean, it's always difficult to define in a vacuum, but what we can say is that, I put it like this: if you take the two extremes, well, what does it mean? It means affiliated. That's, well, I don't know. I mean, dictionary definition of English, definition of affiliated. It's a company. I think the way I put it is, it's enough to say it is a company that's under common control, doing the same business as the defendant, using the same employees and capital as the defendant. That's enough, and we can establish that, or at least it's arguable.
Well, the stem of it is the Latin, is it not? Filius, son of. Latin for son is filius. And the word, the etymology of the word, is from the Latin filius, I think. I'm just asking you a question.
I don't know. You're ahead of me on that. I haven't studied any Latin since I think I've deliberately forgotten when I last learned some Latin. But I mean, obviously, I think there is a connection between the ownership structure, and essentially what my own friend's position is that affiliate has a distinct defined meaning under the DIFC regulatory law, and what it means would apply to our situation if the companies were owned by another company. But because it refers to ownership by because it refers to ownership by a company, this situation is excluded. That's the way, as I understand it, the argument is put. So essentially, what my own friend is saying is, if there happened to be a holding company which owned both Prime and the defendant, then it would be an affiliate, because it would be an affiliate. But because the defendant has no parent company, it is owned by individuals, it can never satisfy, there can be no other company that would satisfy the definition of affiliate other than a subsidiary. That's effectively what they say, as I understand it. And we say that's an arbitrary distinction derived from the specific circumstances of the regulatory law. Now, does that mean that every company that has common ownership, identical ownership, to the defendant will count as an affiliate. Well, our starting point is, well, why not? Why shouldn't it? Because if that's the commercial intent, why should you be able to evade it in these circumstances just because of the organisation happens to be direct from the shareholders rather than indirect? There's no commercial distinction between defining a company by reference to the sort of owner that it has. That's not a relevant distinction. So if the intention is to do something like what is said in the IFC Companies Law, then that intention would be satisfied in our case because they have common owners in identical shareholding structures. And so it matches it, save to the extent that it's arbitrarily distinguishing between companies that are owned by companies and companies that are not owned by companies. And the regulatory law is not really a terribly useful place to look, because that is concerned with corporate shareholders who are governed by DIFC law, DIFC companies and corporations, and DIFC groups. And so affiliate is defined to give content to the question of what is a group of companies, and they decide that a group of companies has to have a holding parent company in effect, and everything falls from that. And it's about, the regulatory law is about regulating those entities, DIFC entities. And that has nothing to do with non-DIFC entities, which are coming together to reach an agreement. These are not DIFC companies. They're reaching an agreement about how they're going to share, what proportion of revenue is going to be shared going forwards. The commercial, if one starts from the position that, for example, the defendant and all of its subsidiaries are called, and if the defendant happened to be owned by a parent company, Prime would be called, then one has to understand the commercial intent of the contract in that context. It's trying to ensure that relevant revenue is captured, and we would say trying to ensure that relevant revenue is not siphoned off in the way that we say it has been siphoned off. So if a group structure is what affiliated company is getting to, we have it, albeit not in precisely the form you have in the regulatory law, which we say is irrelevant because the ownership is the same. The main point, and it may be about common control as well, because obviously it might be, at least if we can show that it's both owned and controlled by the same people doing the same business as is contemplated by the contract, then we would say it's affiliated for those purposes.
But it's common shareholding, is it not? Isn't that?
It is common shareholding.
Common share.
Yes. And there's a question. So my learned friend says, well, it can't just be that, because it can't be our position, because affiliated can't be too loose, because if it's too loose, you'll capture other businesses that aren't under common shareholding. So I think it was he referred to Sotheby's London, for example, and we say that's just a straw man, because you don't have the common ownership, but also the contract that we're dealing with, it has to be construed in the context of the contract. And so it's dealing with the business being done pursuant to the contract. And so the contract relates to business in the UAE. So, for example, if one goes to page 46 of the bundle.
Yes.
Subparagraph 5.1F, the buyer has the right to use the domain name in the UAE, and 47 refers expressly at K. We looked at this, the KPI is expressly about performance K1 in the UAE. So, and we would say it was always contemplated that this contract is about UAE business. That's what it's all about. So it's not about London, and it's not about independently owned businesses. Now, precisely what that definition is, I mean, it's a bit like trying to define what a common law principle of negligence is, or something like that, in a vacuum. that is a difficult process, and often it's actually easier to look at the facts and say, well, does that fall within the definition, even if I don't need to go on and say, well, actually, this is finally, and these are all the things that would fall within it. But we would say where you have a company, it must be sufficient that where you have a company that's subject to common ownership, common control, has the same employees and is doing the same business and is not presenting itself independently from the market, that must fall within the definition of an affiliate. Because the alternative, and we agree, you can't go too wide, you can't capture London Sotheby's. But the alternative is you go too narrow and you really do lead to absurd results, because you do end up in the situation, and we say it's precisely this case, where the defendant can just decide how much of its revenue it has to pay a proportion to. It can just keep itself at the minimum fee and never pay the variable fee, because it decides, well, actually, that business is going to take the money. So between those two extremes, we say lies the answer. But essentially, we say, you do have to read it in the context of the contract. A company wholly owned, wholly controlled by the same people, and that is doing the same business as the defendant, is an affiliated business. If you want to call that a definition, we can. But I say that's at least sufficient, even if it's not necessary. Now, it's the defendant who knows the facts about Prime, what it does, how it was established, what its purposes are, and how those purposes are used. And it's chosen not to disclose them. It's not said anything about that. And we say it would be wrong to say that there is no way, at this stage, there is no way that at trial the court could conclude that Prime is an affiliated company within the meaning of this contract. We say that is well arguable. But as I say, where does it go, even if you put a line through this part of the case? Because we don't know, we don't even know how much money went through Prime, and we don't know the basis on which it did so, because the defendant has not told us that. We've simply, our pleading is on the basis of the CRM data, and if it's just rerouting of what is ultimately revenue generated by the defendant, it's irrelevant whether or not Prime is an affiliate. So we don't even know what the impact would be of slicing this little piece of the case away, because we don't know, but the defendant hasn't told us. So we do say there's an arguable case on this, and no reason to give immediate judgment in relation to it. Then there's three more things I need to deal with: unlawful termination, and then the 2 points on damages, and I'll take them as quickly as I can. But so starting point is it's a 10-year contract. The contractual break clause didn't arise, no one says that. So when we get this notice of termination, that's the 28th of September 2023. That's about a third of the way through the contract, 3 years and 3 months. And they have to justify it. They have to say, these are the grounds, and this is why you were in repudiatory breach of contract. Now, and if they weren't, if the claimant was not in repudiatory breach of contract, then it's inevitable that this is a repudiatory breach by them. And this happens all the time. You'll have seen many cases where one party pulls the trigger and then they both say, well, actually, you were the one who was in repudiatory breach. Now, the defendant says, well, you can just decide this issue now on the basis of effectively of the assertions and the counter assertions that are being made. And we say that is a far-fetched submission, because it's always going to be a mixed question of fact and law, and the facts are disputed. Now, the justification for the termination is shifting somewhat. We don't think we get an awful lot of clarity from our learned friend Skeleton. It is dealt with at paragraph 37 for Skeleton, in a single paragraph. First, it is said, summarising it, essentially, you see the summary at the back end of page 22 of the document, at the top right of the page, paragraph 37.2. There's a refusal to facilitate a proposed rebranding. It's the first allegation. We say that substantially mischaracterizes what happens. No particulars are given here, but there we are. It's not said, for example, the claimant should have done X but didn't do X, or should not have done X and did X. And then the other argument is the accusation of fraud. And it's said that that justifies termination. Now, the paragraph of the law that is actually relied on, you'll see this at paragraph 37, is Article 86. And we ought to go to that. That's page 3415. It's not quite the same, but it's a similar structure to English law. So there are two ways you might be able to bring a contract to an end. One is Article 86, and that deals with past breaches. So it's saying a party may terminate the contract where the failure of the other party to perform an obligation amounts to fundamental non-performance, and explains what that amounts to. And that exists in common law as well, but in a slightly different form. If I do something that so fundamentally destroys the contract that there's no point in going forward, you're not going to get what you're entitled to under the contract, I can stop it right there. More usually, people go to Article 88, which is over the page, which deals with anticipatory non-performance. And so they say, well, because of what you've done in the past, I'm entitled to conclude that you will not perform in the future. There will be fundamental non-performance in the future. And we say it is quite unclear what is actually being asserted here, because the skeleton argument clearly refers to Article 86, says it needs to be read with Articles 77 and 88, but it's saying it's an Article 86 termination point here. And these are two different concepts. The documents, though, seem to be saying more in terms of what's going to happen next. And so there's a conflation there, but there we are. As to past performance, normally what you'd expect is a party to say, well, look, you didn't perform, it caused me so much harm that, you know, we bring this to an end, we can't go forward. And the reality of the situation is the defendant, in relation to rebranding, did go on and rebrand. It wasn't much delayed. It was delayed by 2 months. Through the whole set of proceedings, start to end was 2 months long. So even if there was a dispute, a breach, which we dispute, it wouldn't have caused any harm to them. And they don't identify the term of the contract, or well, perhaps they do, but there we are. It would not be fundamental non-performance to say, we don't agree with your rebranding process. Let's get somebody to decide whether you can do this by yourself without my agreement. And I certainly previously understood the argument to be largely about future performance. That's the Article 88 point. So it is quite confused, we say. And the assessment inevitably depends on the facts. But just dealing with those, what do we say about this? First of all, Mr. Fontmanti makes clear he didn't refuse to rebrand. You see this at page 1089, and I'll show you the underlying documents briefly. We won't have time to go through all of this, that's for trial, but there we are. So he says in paragraph 100, 1089,
yes,
he explains what was going on. He said in relation to, so he talks about the two justifications given, and he says in relation to the former, although I did not understand the reason behind the rebrand, or the urgency, I never refused it. Instead, I proactively requested to meet to understand the reasons and had long conversations with the defendant to accommodate its request. I even accepted the rebranding, but the defendant then requested to remove the variable component from the PSA as a deal breaker, and so on. And then he asked for the audited accounts, and you can see that from the WhatsApp messages. If one goes to page 1270, and we do say this is quite revealing, these messages. Again, I'm not going to show you the whole chain, but you can see a WhatsApp message from Mr. Texera, and he says, hi, Oriel. Do you see that in the middle of the page? Please see the one highlighted in green. So this is the proposal. There will be no performance fees once we execute the new agreement of any of the 3 countries. So what's happening is that they are trying to get out of the obligation to pay performance fees at this stage. That they're trying to lump it together with the branding. And if you go to page 1268, you can see that. So if we go back to, you've got Mr. Fontmante sending an email, WhatsApp to Mr. Texera. He says, Ben, I don't understand this change in the last minute. We agreed that for UAE, we'd do an amendment to the existing agreement, changing only the brand, the domain, and the duration, but the rest should remain as it is. If you review all our emails, this is what we agreed. And in all our conversations on the phone, this was always very clear. In fact, even in my last email, you replied confirming all changes that need to be done in the amendment. And the variable was never mentioned. I'm happy to move ahead if we are consistent with all what has been discussed and agreed until this morning, but not with any additional changes to our existing agreement. And then over the page, he says, I'm doing already an effort removing our brand from our agreement, and you need to put yourself in my position. And then 1273, he says an email follow-up. You'll see at the top of the page, this is now 21st of July. I'm ready to move forward, as long as one, we don't change any of the terms of the current agreement, except an amendment covering the rebranding. And then two, you bring Ellie to the table to discuss Spain. So there was another issue where the claimant had been cut out of a deal in Spain. And he's saying, well, look, we need to talk about this. He's not demanding that he gets paid for it. But ultimately, we say there's credible material. There is a factual dispute. And when one thinks about what's being said, the conduct that's alleged is conduct that's said to be so significant that you just can't trust them to go forward with the contract. And even if you can construe this as him saying, I'm happy to go forward with branding on conditions, that's relevant to the question of whether or not he's saying, I'm just not going to perform in future. I'm just refusing to do this. Whereas on the other hand, you've got the defendant saying, no, whatever we do in the future, we're not going to pay you these sums. So if you go back, for example, to page 1272, to see the defendant's position in this. He says, hi, Oriel. We cannot go ahead with any performance fees on any country. Can you explain why? It doesn't work with our financials. It's a one-sided benefit. If the market fails, we still have to pay fixed fees. Precisely the opposite of how I see it. So that's Mr. Texera, just before the rebranding bubbles up.
What date's this? What date is this?
I think this is also in July. So you will see, I think it follows on from the previous page, which has got the 12th of July written on at 1270.
There's a 3rd of July on page 1271. Message date, me, 3rd of July. Mr. Teixeira.
Yes, I think so that's being copied into the chain. And he says this email is as sent on the 3rd of July. So I think this comes after the 3rd of July. I believe it's contemporaneous with the others, so the 12th or the 13th of July. We don't have the precise date for that, I'm afraid. And then the email that I showed you followed on from that on the 21st of July. But essentially the battle at that stage is they're saying we don't want to pay you fees anymore. We want you out. And so we say that there is a credible, reasonably arguable case that they knew that they had to pay him very generous fees given the market had surged, so quite a lot of money. They felt now that that was an unfair deal and they wanted to get out of it. And the rebranding is part of that. Now he's saying, all right, let's go forward with the rebranding, but we've got to keep the contract the same. And they're saying, no, under no circumstances are we going to do that. And then they decided to go ahead with the rebranding without him in any event. So that's the first point. There is a factual inquiry to be undertaken in relation to that. And the second point is, it was the claimant's case is that he genuinely believed that they were not entitled to rebrand unilaterally. Now I've shown you the clause and I won't go back to what it was. But essentially, he felt he had value in that co-brand. He felt he had a reason to insist on the clause and a right to insist on the clause. And what he didn't do is fold his arms and stand in the corner and say, I'm going to block it. He said, I'm going to take it to a judge, which is the right thing to do if there's a disagreement that can't be resolved and needs to be resolved immediately. The judge disagreed with him, but what we say is on this issue of anticipatory breach or future performance, it can't be an anticipatory breach of contract to go to a judge and say, I want to enforce my contract. You're doing the opposite. Now, as to the question about alleging fraud, we say those are quite proper allegations to make in the circumstances. They're quite proper allegations to make in this case. Those are made on. He didn't show up at court and say them himself. He instructed lawyers to do the job for him. And if it was improper to do that, I'm sure I will be told at some stage that I've overstepped the mark. But in my submission, there is more than ample evidence that there's been deliberate concealment of and dishonest concealment of revenue here to make that allegation. Now, does it completely poison a relationship and mean the end of every long-term contract if one party says the other's been dishonest? And we would say there's no general rule to that effect, but obviously there's a prior question, which is, have they in fact been dishonest? And if they haven't, was it nevertheless reasonable? What were the circumstances in which those suspicions arose? And then, in the light of that, if it was unreasonable, does that mean that they can't work together going forwards? And all of that requires factual investigation. There's no rule of law that applies here. Now, in his evidence, Mr. Texera made another argument. What he said is that the claimant had stopped providing services. You find that on page 100, page 54. The response to that is that, in fact, what happened was the defendant blocked the claimant's access to the necessary services. You can see that pleaded out at paragraphs 26 and 27 of the statement of case. That's in the original one. It's supported by a statement of truth, and therefore you can accept that. And you can see the claimant demanded that the services be restored on the 27th of September 2023. So they're saying in terms, let's get on and work together. We've got to get back to working together.
I was going to ask you about that. I was going to ask you about this. What is the precise sequence? I have it in my mind, and I need to be corrected if it's wrong, is that we get the judgment, and then on the same day, the claimant makes these demands to perform, in effect, you're saying, and then the next day there is the termination notice. Is that sequence correct, first of all? That's the first question. Second question, there's no referencing of where the claimants, as it were, sought to perform. You say in paragraph 27 of the pleading, on 27th of September, L.l.c demanded that the above steps be reversed.
Yes.
And notified Sir that it considered the agreement to be in full force and effect. Where is that?
We don't, I'm afraid I asked that question last night. We don't have that in the bundle, unfortunately. So you can't see the actual document. But what I say about that is, if one goes, it's in the pleadings. Page 28 of the bundle is the original pleading. It's supported by a statement of truth, and therefore it's asserted. I don't think it's disputed. I mean, we don't have a defence to know what's disputed, but that is the sequence. So essentially, on the 27th of September, we get the judgment. On the same day, the claimant says, reverse the steps, give us access to allow us to do our job. We consider the agreement as in full force and effect. And then the next day, the defendant writes to say, no, we're terminating. So we say, when one looks at that, I mean, the reason I looked at this was because it's not advanced in the skeleton argument, but it is said in Mr. Texera's witness statement that the claimant stopped providing services. And the justification, the reason why it couldn't do that for a while is in paragraph 26 of the pleading, because you can see the steps that were taken. It revoked L.l.c's access to social media, refused requests about social media, revoked access to Google Ads, excluded PR manager from PR team meetings, and frustrated its ability to provide SEO content generation services. So it was effectively taking steps to stymie the supply of services. And in that context, we say they can't rely on their own conduct that prevents the claimant from failing to do things under the contract. Sorry, prevents the claimant from doing things under the contract, and then rely on that failure to justify termination. And that's for two reasons. One is the Article 78 point in the law of contract, and the other is if the defendant has caused that behaviour, then it's not an indication that the claimant is not going to perform in the future. That's the point. So that's where we say there's obviously an argument to be had on unlawful termination, and the two grounds that are alleged to justify it. Who knows? Maybe they will be made out. We say that that's a difficult case for my learned friend, but one way or another, it's to be decided on the facts. Sorry, do bear with me 1 second. Sorry, I've just got a you don't, as I say, you don't have a copy of the letter where the claimant says we consider the contract to be in full effect. You do have references to it in other correspondence. I mean, if there's an issue about that, we can certainly provide it to you. I don't think it's a disputed document, as far as I can say. I don't think there's any dispute about the fact that that is a fair summary of what was sent.
Right.
So the last two points are about damages. So first, it said that the sums claimed are unparticularized and artificially inflated. That's skeleton argument, paragraph 39. We do consider this to be an obtuse complaint. I mean, the suggestion that was made already is that what we should have done is plead less, which I find quite strange, if I'm honest. It's not a helpful way to approach a case, to seek to strike out their case because they've said too much. We do provide various, I've shown you the pleadings, but there are other breakdowns of how those fees are calculated. So, for example, in relation to the past fees, 1094, there is a further breakdown of how it's all set out, and then there's a detailed explanation in the pre-action letter of claim at 1014.
Yes, I've read that.
I'm grateful. Now, if there was real doubt, I mean, it's actually a fairly simple calculation. It's not, I mean, you will have seen much more complicated damages calculations than this. And there aren't very many inputs in terms of variables. And if the argument is you've done the calculation, you've got the wrong structure, they could have said so. They don't say that. If the argument was some of these variables are wrong, they don't say that. What they do say is to sort of take pot shots at effectively trying to leverage the fact that they've refused to provide any information at all. So paragraph 40 of their skeleton argument, they say, well, it's not enough. They say L.l.c, third line, L.l.c suggested that projected gross revenues will simply be identical for every year between 2025 and 2030. That is not a sufficient or proper basis for calculating gross revenues. And they're entitled to better particulars, more accurately pleaded case. What is their case on what gross revenue will be in the 5 years? Everybody's projecting that because we're looking to the future. As between June 2023, so we know up to June 2023 for what's in the CRM. As between 2023 and trial, they will know that. They will know every penny of that, but they don't want to tell us. And after that date, after trial, whenever that may be. It's going to be a matter of projection. It's not going to go down to zero, and the court will have to do its best. But that's what courts do when they assess quantum. But again, we say it's perfectly reasonable to take your starting point to assume that revenues will remain the same. And in fact, that's the safest thing to do. One might have done it more aggressively and looked at the growth rates and continued to apply them. But we didn't do that. We kept it flat. So we say it's actually a conservative estimate, unless they can show some massive drop in market revenue, which they have refused to provide. 40.2, the other point they make, they say we haven't given any credit to or disclosed alternative income or revenue that could have been generated, but there's no evidence that there is any. And of course, they will be entitled to say there's been some or ask questions in due course, but that doesn't make the claim lack real prospects of success. So that I wasn't going to go back over the pleadings. I think I've said enough about that. Then there's the complaint about multiple damages. You've seen the provision of the law. It's Article 40, subsection 2 of the Law of Damages and Remedies, 3545, just in case you want to see it again.
Yes,
Probably had enough of it.
I'll have it up while I'm listening to you.
Thank you.
3545.
3545. I think you heard that there's been a bit of debate about whether or not the 3 times, because it says you can have 3 times, no greater than 3 times the actual damages, whether 3 times includes the actual damages or is an addition to the actual damages. And there is a different school of thought. There are 2 different schools of thought on that. So if we wanted to maximize the claim, we would have come to the court and said, that means 3 times plus actual, and we're claiming the whole lot, thank you very much. So the net total is 4 times. But we don't do that. We've said, look, of course it's discretionary, but this is what we're going to be telling the court is the right answer. My own friend says, well, you shouldn't do that. That's an odd submission. What parties don't normally come to the court and say, it's in your discretion, do what you think is best. They normally say, it's up to you, but this is what I would do, or this is what I would suggest you should do. And that's what we've sought to do. This is, we think, we would suggest, potentially a very serious fraud that's going on here. They say a few other things. They say this provision doesn't apply to claims for breach of contract. And the reason for that is they say if you go back to Part 2 of the law, you get a complete code for contract damages. Part 2 is 3538.
Yes.
Damages under the law of contract. Now, we say that can't be right because for a range of reasons. But if you go, for example, to 3541, you've then got Part 3, top left, you see that damages in the law of obligations.
Yes.
So that's tort law. So on this logic, this sort of structural argument, you've also got a complete code for damages in tort. So then what does damages in Article 40 actually ever apply to? It doesn't apply to anything because tort's excluded and contract's excluded. But it gets worse because the way the scheme works is they say Part 2 is contract damages, Part 3 is tort damages, and then Part 4 is just other remedies. You'll see that starting at 3543. That is then divided into 3 chapters, and chapter 3 is at 3545. And sorry, yeah, that's right. Other remedies 3545. There we are. And you will see that other remedies provides for various things, including, look at Article 39, specific performance. Specific performance of what? Of a contract, obviously. So these remedies apply clearly to claims in contracts, because otherwise, what are you getting specific performance of? And indeed, if you look at Article 40 itself, it deals with it has two provisions, 41 and 42. 40 subsection 1 also deals specifically with specific performance. That's the provision that allows for what in England would be equitable damages in lieu of an injunction.
Yes.
So the idea that these are not remedies that apply where the claim is in contract just cannot be right on the face of the law. And 42 doesn't say anything of the kind. So the structural argument, if I can put it like that, just cannot work. And you're onto this because you've seen a bit of Al-Kharafi, and we had that discussion about it yesterday. But there wasn't a similar argument made in relation to the regulatory law, that because the regulatory law was a complete code, Article 40 didn't apply to remedy to claims under the regulatory law, and that was rejected. Your Honour has read that, but while we're talking about it, just to show you why it was rejected, could we go please to page 2900?
Yes.
If you look at the middle of the page, I think the submission may have included a suggestion that the reason that this was particularly egregious was because it was a regulatory offence. But actually, if you look at the judge's recital of his earlier judgment, top right of the page, but in the quotation at paragraph 18, he does say it's deliberately seeking to avoid compliance with regulatory requirements. But then he goes on to say, this is not a case of the first defendant making a mistake. This is a case of the first defendant deliberately falsifying its records in order to mislead. That, in my view, is conduct in relation to which this court ought to mark its disapproval by making an order for costs on an indemnity basis. And then he relies on that to say, and that is similarly conduct on which I rely to say I give damages under Article 40, subsection 2. So it wasn't just because it was regulated. These are not confined. My learned friend's effectively advancing the opposite of the argument that was put there, which was that the regulatory claims don't have 40 subsection 2 claims. He seemed to be suggesting that only regulatory claims attract 40 subsection 2 awards, and that is not the position. It was the deliberate falsification of records in order to mislead. It's the dishonest conduct which was at the heart of it. In the skeleton argument, my learned friend says Article 40, subsection 2 does not permit the award of additional damages in cases of breach of contract. And then he says, save potentially in the rarest and most exceptional of cases. The first part of that, insofar as it's advanced, is wrong. It does. The second part of that relies on, moves forward, relies on, in effect, equating additional damages under DIFC law with exemplary damages under English or US law. And it's certainly not English law exemplary damages, and we can see that, in fact, from the same page, 2900. So John Chadwick looks at that, just under where we were looking at. He says, nor do I think, do you see that? Nor do I think that Saracen Alpin obtains assistance from the principles which would guide a court in England and Wales when deciding whether or not to award exemplary damages. For Article 40, subsection 2 is not derived from the law of England and Wales. Rather, it reflects an intention to depart from that law in favour of the law of the United States of America. The law-making authority in this jurisdiction has given the DIFC courts power to award multiple damages in appropriate cases, and goes on from there. So my learned friend says, oh, well, that must be wrong, and he's got some arguments as to why it's wrong.
Well, he says that the US law does not do that in relation to the law of contract, damages for the law of contract. As I understand the point. He'll correct me if I'm wrong, but that's what I thought he was saying, that this judgment is wrong because the judge was wrong about it reflecting an intention to depart from that law, English law, in favour of the law of the United States of America. That's how I understand.
But his central point was you've got to be guided by the legislation. And that's why he was saying it's not that helpful. He was saying it's not helpful for me to look at English authority. So if you think about what's happened, counsel from England has put in front of him a whole load of English authority and said these are very rare. And he's saying, I'm not terribly interested in that because A, I don't think it comes from England. Here's where I think it comes from. And B, I've been told by the legislative authority that these are the circumstances in which to make an order. So I'm going to work out whether or not those circumstances apply. And then I'm going to have to apply my discretion to the question. And those are all factual questions which cannot be ruled out at this stage. And so when my learned friend says, well, this is a routine commercial dispute, we disagree with that. We consider that the defendant knew what it was supposed to be reporting, and we consider that the defendant has contrived an argument based on an obvious error in the agreement, which, when it's totally clear, A, what it meant, and B, that they knew what it meant. And they presented it internally. I mean, if we think back to that photograph, they knew what their revenue really was. And if one thinks back to some of those emails, they knew that the fees would be determined by reference to their revenue. And they didn't come forward and say, well, look, this is what we've done because this is our position. They took that decision for my client. And so this is our case, that they basically, whether they came up with this argument before or after these proceedings, we don't know. Maybe a trial will shed some light on that. But one way or another, they've come up with an argument which they must have known was completely opposite to what everyone had intended to agree. And they applied that. Now, I might be right about that. I might be wrong about that. What I do say emphatically is that Your Honour is not in a position to say today, I have no real prospect of establishing it. And it's not just that. It's how it fits into the picture. And I've just got 2 more minutes, and then I'll hand over. Or maybe 5. Sorry, yeah, less than 5. It's how it fits into the picture as well. It's this, we say, part of an effort just to get my client out. And so you do have to look at the bigger picture. So if one thinks through the sequence, you've got underreporting of revenue, and then an attempt to negotiate away the variable fee. And that would have and if my client hadn't cottoned on to this, that could have put a lid on the whole business. And my client may never have discovered that this was happening, because as far as they knew, business was going fine, about as expected, but not particularly well. And so they would never have known that by agreeing to end the variable rate, they were giving up not just the odd 300,000 dirhams here or there, but they were actually giving up millions and millions of dollars of revenue by agreeing away that entitlement. And then you've got, what happens next, which is the determination, which we will say was part of it, is a pretext that's been given to seek to terminate, and then the offensive that has happened since then, which we do say is egregious conduct and is part of trying to prevent my client from vindicating its legal rights, which will include accusing him without any basis of hacking, and on the basis of that, getting his passport, my client's CEO, getting his passports confiscated, and trying effectively to frighten the claimant off from this claim. And we do say that is what is happening. And we do say that is egregious. And we do say it is all part and parcel of this breach of contract, of trying to, in any way and form, not give the claimant what it deserves under the terms of this contract. And so my learned friend says, well, because it's rectification, there's just no way you can get home on this. And we disagree with that completely. But it all depends on the facts, and depends on what they knew and what they thought, what we can show that they understood about all of this. So those are my submissions on the damages element. All that is left is the amendment. You've got I think our position in relation to that. You've got the amended pleading. I've shown you the express pleading of rectification. The only point I think I make in relation to this is that if you do come down on the side of saying, well, we think there ought to be more particulars, that is not a reason to give summary judgment, and there's a decision in the bundle about that. You can see it. It's called Nexo. It's found on page 2519, and I refer you to paragraph 123 of that. In relation to one part of the pleading, that's 1674. There is an issue raised about how Mr. Fontmante discovered the information about underreporting. And he sought to correct his version of what happened, or sorry, augment his version of what happened. There are some corrections in there as well. The defendant makes quite a fuss about this. It's unclear why, for the purposes of these proceedings. It's not relevant directly to any issue that will arise in the claim. It's more background than anything else. And the concern is that this has got something to do with the criminal complaint that's going on. But there we are. The amendment is what he says happened. And so clearly, I mean, it just makes no sense to oppose that amendment. Tell us what you think happened. Well, this is it. Well, we oppose it because we don't believe you. Well, that's okay. He could be cross-examined on that in trial, but it's just obstructive to say don't put your case in your document. It makes no sense. And there's a corresponding amendment proposed to the claim form, which adds the claim to rectification, just so you've got it. That's at page 1661. And you'll see at paragraph 8, it adds the claim for rectification, and also over the page at 1662.
I'm using a different pagination, but yes, I'm following you. So it's the version where rectification is added at 1650. That version of the amended particulars.
I think I've been doing quite well with pagination so far, but yes. So no, I was talking about the claim form. So sorry. So
sorry,
I've mentioned that there's rectification is added to the particulars, but then at 1661 it was. You'll see the amendments to the claim form. In fact, it starts at 1659. There's an amendment to the claim form, and then we add the rectification claim at 1661 with your permission, of course, and also at 1662 in the prayer. And I won't go back over why we say it is adequately pleaded. You wouldn't expect detailed pleading in a claim form in any event. I don't think the point is made about this.
No.
I think in relation to just on this final point, in relation to the factual question about the access to the CRM system, I've shown you the emails which show that the intention was to give the claimant's team access, and you can read for yourself the account. I think what is said against me, at least in writing, is that they want an explanation of why the account has changed. We don't say it's changed very much, but anyway, they're not entitled to cross-examine us as a condition of an amendment application. If that's what my client says happened, and that's what he says happened, and if they take issue with that, they can ask him questions about it, either in written requests or in cross-examination, if they think it's a worthwhile avenue to pursue. Your Honour, you've indulged me for a very long time. Is there anything else? I completed my submissions, but if there's anything else that I can help with.
Not at all, thank you. Both of you have been most helpful in answering my questions, some better focused and better informed than others. Now I hope I'm fully informed of both of your cases. And I'm going to hear a little bit more, I know, shortly. But at least I wasn't far wrong in how long it was going to take to deal with all of this on my preliminary viewing of it.
Yes, understood. Noted.
Right, and it's not all down to my questions either. You've both had a lot to say, rightly so, and I've listened attentively and asked some questions. So thank you. But we have a little more to go. So I will come back now to the defendant for a reply, and I'm sure, Mr. Potts, you will keep it to a reply and not repeat points that you've already made very forcefully before me.
Yes, my lord. I mean, obviously at the outset, the really all the issues continue to be in dispute. So if I don't touch on a particular point, it's in the interest of brevity than a concession. Can I just start with 2 points which may be relatively unimportant in the context of the more important issues, but one relates to the business license allegation. I made clear at the outset that we weren't pursuing this complaint for the purpose of the applications before your lordship, but my learned friend has suggested this complaint should never have been made on the basis of an assertion that the business license was at all material times in continuous effect. And I just want to make clear that we do not accept that, and I can show you why we don't. Can I ask you to look, please, first of all, at page 1052 of the bundle.
Yes.
So this is part of Mr. Font-Mante's witness statement, which was filed and served in response to the application. When the application was made in December, it was supported by a witness statement to Mr. Tessera, who exhibited the existing license that had expired in November 2023. Then there was a bit of skirmishing about the timetabling of everything, but we only got this evidence from the defendant in January, and you'll see the date of the witness statement at the end of it. It's dated the 20th of January, 2025.
Yes.
So if we go back to that particular paragraph, nothing was said in this about the continuity of the license or the circumstance in which it had been renewed. All that Mr. Font-Mante said is, he says, although I do not see the relevance of this point to the strikeout application, it is not correct that the claimant is trading in breach of its licensing obligations. A copy of the claimant's current license at pages 4 to 10 of OFM1. Now, that document, which was exhibited, therefore, for the first time in the exhibit produced on the 20th of January, if I can show you, you'll find the relevant page at page 1096.
Yes.
And at 1096, you'll see that the license that's produced now, which is a new version of the license, is said to expire on the 15th of November 2025. You'll see that about halfway down the left-hand column.
I've already looked at this and highlighted that.
But at the very bottom of the page, just above the Emirates logo, can you see the print date? The print date is the 18th of December 2024.
Yes.
So this document appears to have been generated for the first time 2 days after Mr. Tessera's evidence was filed and served, in which he pointed out that there was no current license. So all we know is that this license document was generated after we had complained that there wasn't an existing license. And there is no evidence that this was renewed as of the 2023 date, or that it was in force on the 16th of December.
Well,
now, obviously,
it might have been retrospectively.
Yes. So the inference we would invite you to draw, but as I say, it's not that important because we don't pursue it for the purpose of the application. But we also do not accept the Mr. Tom Montague-Smith's assertion. This assertion should never have been made. It was made because at the time, the only existing certificate available showed clearly an expiry in November 2023. And we only then got this produced version for the first time after our evidence was filed and served, suggesting it was only generated after our evidence was filed and served. So we don't accept the assertion that the assertion was wrong to make, or that it was wrong to make an application premised on the notion there wasn't a current license. Now, we're not pursuing it because we've now seen for the first time after our evidence was filed and served a current license.
Very well. Let's move on.
Can I just ask the question? Sorry, just on this, I do apologise for intervening. The complaint that I actually made was my learned friend remained positively alleging in oral submissions that my client traded in breach of license for a period. Now, he has no evidence for that. It doesn't.
I don't recall myself making.
You did say that. We did say that.
Well, it'll be on the transcript, but I really regard this as a minor issue in all that I have to decide and weigh. So let's move on. I can understand why you each wish to state your position on this, but it's not really very helpful to me on the substantive issues I have to decide. So please carry on with the rest of your reply, Mr. Potts.
Okay, the next point I just wanted to touch on, which I suppose relates to the evidence. Can I just ask you to look, please, at page 1210 of the bundle? You recall that there appears to be a tension in the witness statements as to whether the agreement was drafted by Mr. Fontmante's side and sent to us.
Yes.
Whether it was the product of a joint drafting exercise. And what you'll find at page 1210 is an email from a lawyer called Arahant Mota at unitedadvocates.com. There's an email of the 1st of June 2020 sent to Mr. Fontmante, copying into a team of other lawyers at United Advocates. And this appears to forward to Mr. Fontmante only the draft or a draft of the document. And then you look above, Mr. Fontmante then forwards that to my client for the first time, saying, here it is, finally.
Yes.
So that is consistent with my client's evidence that this was sent to us by Mr. Fontmante. It wasn't a document we drafted. And it looks, with greatest respect, as being a document that followed his instructions to his lawyers, whatever the agreement might then have said, or whatever was implemented in terms of paying for the fees of those lawyers. This was his lawyers drafting a document which he sent to us. Now, the exhibit to this document, or the sort of the attachment to it, is the one which you see starts at page 1212. And you can see that this is a draft of the agreement. Some points to note, if you look at 1215, the definition of gross revenue, so drafted, it would seem, by Mr. Fontmante or his lawyers. At 1215, gross revenue is referring clearly to the seller, bottom of 1215.
Yes, I see that.
And then the draft, if you jump forwards to page 1218 and 1219, for example, to 1218, there's some fields which are in blank in the consideration sections. 1219, we have again the same drafting as in the original, or in the executed version. In section 4, combined gross revenue per year of the parties, so far as the seller note purchase consideration is concerned. But if we go over to page 1221, again with some blanks in some of the clauses, the same different wording in clause 5G, simply referring to the combined gross revenue, not the gross revenue of the parties. And then you can see that matters still had to be inserted in other pages of the draft. But can I ask you just to look at page 1230? 1230.
Yes, I'm there.
You'll see there's a drafting note. Drafting note, additional active business contracts, if any, to be added by the seller. So that's Mr. Fontmante. And then 1231, drafting note, list to be provided by the seller. So now, for what it's worth, at 12:37, there's then an email from Mr. Azar to Mr. Oriel Fontmante saying, here's the deal sheet from Sotheby's. Please sign and send me the final document with this annex to sign from my side. I'll prepare the check as mentioned in the SPA to give you post-signing. And then you'll see that at 12:38, there's the schedule of the Sotheby's transactions. Then there's a debate at 12:39. You'll see an email with Mr. Fontmante, it seemed, said, hi, George, according to you, all these deals shouldn't count towards the gross revenue to be calculated for the seller's note or the 5% marketing fee, or none of them. Now, we would say that's a clue that there is a different gross revenue provision in clause 4 to the one in clause 5. Now, again, you'll have to read through all the evidence that's been put before you rather than just, let's say, picking on isolated examples, and you'll have to read it knowing that neither side has conducted yet a full disclosure or production exercise. But it takes me to my core point, and this is the most important point for the purpose of this application. My learned friend has shown you, rather unhelpfully, the outdated decision from 2009 in Chartbrook and Persimmons. The Lordship asked him, was that a case about rectification? And he said, no. Actually, if you read it, it was a case about rectification. And I can show you the head note and the judgments that deal with the rectification elements of the case. But in that case, Lord Hoffman introduced what, in a sense, was fairly heretical proposition that interpreting a mistake out of existence is roughly the same exercise. Now, that was in 2009, but all the authorities I've showed you since then, the 2 or 3 I've cited in my skeleton I showed you, come back to the point that in order to interpret a contract on the basis it contains an obvious mistake, the mistake has to be obvious, clear, unambiguous. Now, I'm not going to paraphrase all the authorities I cited yesterday. My learned friend didn't take you back to any of them to say that any of them were wrong in a statement of the law. But when you then look back at the particulars of claim, which I think it's 1629 is where it starts.
Yes.
We need to look very critically and analytically, please, at the paragraph that we complain of in particular in this respect, which is paragraph 7, so at page 1634. Because in 1634, the assertion is made at 7.1 that the reference to seller is a manifest typographical mutual mistake. And the parties intended this should be a reference to the buyer. Now, then the particulars are given for that assertion. And the particulars don't actually justify it, even if you assume them to be correct when they're demonstrably not on the face of the evidence. Just by way of example, 7.1.2, the assertion is made that SIR is under strict obligations to report revenues to L.l.c. And then halfway through that paragraph, it says there are no equivalent reporting obligations imposed on L.l.c. But I've shown your lordship the clause 5.1m that does impose reporting obligations on the part of L.l.c. Now, if we look at 7.1.3, it suggested that the parties always understood the definition of gross revenues, including that related to SIR, the buyer, despite the express definition both in drafts and in the executed version being gross revenue of seller, and despite the differences between clause 4 and clause 5. It then says at 7.1.3, the partnership fees were set and actually paid for in the period between 4th of June 2020 and the end of June 2023 by reference to the revenues of SIR, the buyer. This included payment for $366,000 paid to L.l.c based on gross revenue as reported to L.l.c in relation to the first year of the agreement. Now, just pausing there is no evidence and no suggestion, indeed it's contrary to the claim itself, that there were any such calculations or payments made for year 3. And you have to also remember that the structure of the agreement, there's another part of this which is all broken down, what's gone wrong in this pleading. But the first year of payment was a fixed fee of 2 million dirham, come what may. So June 2020 to June 2021, that was a fixed fee with nothing about variable payment. For the second year, June 2021 to June 2022, the concept was there would be a fixed fee, which of course was paid, but the variable element might kick in terms of the 5% of gross revenue of the seller. So that is what we suggest is going on when that invoice is presented in September 2021, because it's essentially in the beginning of the following year, a demand for payment of 5% more than the fixed fee based on the previous year's calculation of the gross revenue of the seller. Now, I appreciate my own friends got a point about whether the evidence on that is consistent with both sides of each other, or what the court can make of post-contractual evidence. But in any event, when we then get to the amendment agreement is specific as to what is going to be done in terms of payments for 2021 to 2022 and 2022 to 2023. And clause 4, my learned friend hasn't really satisfactorily addressed, fixes the amounts payable.
Monthly amounts payable.
The monthly amounts payable, precisely. But we never received, there's no evidence of an invoice being submitted by Mr. Font-Mante for the following year.
And you though, haven't submitted in evidence, unless I've not seen it or not been directed to it, any calculation based on your client's interpretation of this variable payment, quantifying a figure by reference to the revenue generated solely by the claimants, have you?
We haven't. We haven't reached that stage of the case. Our point is that we're trying to debate whether or not, for the purpose of this pleading, it is plausible, credible, or realistic to allege that there is a manifest mistake on the face of the contract when you have a defined term that refers to the seller. We say you don't even need to get into post-contractual conduct to analyze whether or not there is an error for the purpose of interpretation. It's a completely different question.
I have your point on that.
So rectification is a completely different point. But the errors in these paragraphs in the pleading, because this paragraph, 7.1.3, is not only identifying as one example that alleged payment, but it's positively alleging that the partnership fees were in fact set and actually paid for every year, 2020, 2021, 2022, 2023, by reference to that form of calculation. And there's no evidence of that. Now, another example of the difficulties, but I mean, they're sort of different orders.
I'm sorry I'm listening to this, trying to work out what is a reply here, because these are new points that are being made, and they're not even made in the evidence.
Well, that is just crossing my mind as well.
I mean, I've seen evidence that deals with these points, but my learned friend doesn't put them out. He comes in with a reply, which is not. It's just a new series of points.
Well, the point I'm trying to make, Your Lordship, is essentially this. This pleading does not engage with the legal test for interpreting a mistake in a contract on the basis it's a manifest error in circumstances where it is impossible to construe the word seller as buyer. Now, that's the complete answer to that pleading. We're then into the territory of rectification, and we've always tried to make clear, while you could pejoratively characterize it a pleading point, our position is that if this case is a real case, it's a case of rectification. There are two different exercises for the court to perform. The claimant's evidence, the long evidence of Mr. Font-Mante, appears to be designed to build a case for rectification, to say it's all dreadfully unfair because what I thought we meant was this. But what it doesn't do at paragraph 7.1.6, which is the one at page 1636, paragraph 7.1.6 at page 1636, This paragraph, the totality of the pleaded allegation for rectification, suggests that the definition should be rectified, where for the reasons set out in paragraphs 7.1.5 to 7.1.6 above, the parties had the common intention the definition should refer to buyer at the time of entry departure.
There might be a typographical error there.
I think the cross-referencing has gone there.
Well, there is.
Obviously.
Well, we can talk about whose obligation it is to reply or make a case, but that's an application for permission to amend. And in my learned friend's skeleton on this point, buried in his skeleton, I can try and show you the footnote to this effect. He has a footnote. If you look at page 21 of his skeleton, at footnote 9.
Just let me get there. I'm scrolling.
Yeah.
Yes.
So there's a footnote 9 given at page 21. And what is said in a footnote is that the draft paragraph 7.1.6 makes an erroneous reference to 715 to 716 instead of 7.1.1 to 7.1.6. However, the claimant's made the correct reference clear to D. It's obvious. And if the claimant's given permission for the amendment application, this will be corrected. Now, in a sense, fine. But the court is being asked to give permission to amend, to plead a rectification case, which doesn't actually particularize the constituent elements of the claim in equity for rectification, doesn't plead the constituent elements that's set out in the law that we've already looked at. It casually has a typographical mistake which nobody sought to correct in the draft before your lordship. And it is, in our respect for submission, critical when you look at part 17 on statements of case and what should be pleaded, that things like, for example, an alleged agreement that's said to have been conducted orally, or that's meant to be set out in communication such as email traffic, or that's meant to be concluded by conduct, all those matters have to be particularized if you are going to get to the point of pleading out a contract or a rectification of a contract. At the moment, we don't know if the totality of the pleaded case for rectification are the points made in 715 to 716 or 711 to 715. And it's not good enough to say, well, that's all going to come later. It'll be a matter for evidence or a matter for request of further information. This is the application for permission to amend. And it's trite that the applicant for permission to amend has to satisfy the court that the pleaded case is properly particularized and discloses a real cause of action or realistic prospects for success.
Right.
At the moment, we'd say it doesn't.
This is definitely not reply. You've made that point numerous times. So move on to something else, please, in reply.
Well, the only final point, really, in the interest of time, is that my learned friend has, I think, clarified that there isn't any claim for anything other than a breach of contract. There is no claim for a fraud in tort or under the law of obligations. What is simply being suggested is a breach of contract or various breaches of contract, because one breach appears to be the complaint about the revenue accounting, the next complaint appears about the termination, but that behind that it is suggested that there was no possible explanation for any of that except for deliberate dishonest conduct on the part of the defendant. Now, as it happens, of course, there is a pleading point, but an important one, about particularity of pleading dishonesty. But equally, a dishonesty plea should not be allowed to go forwards if the actual circumstances as alleged, the actual facts and circumstances, are just as consistent with either an innocent or negligent or mistaken analysis of the law, for example. And the point I'm making here is that that entire theory of dishonesty cannot survive immediate judgment in circumstances where the claimant's own case requires the court to either rectify the agreement or interpret it in a way which is not consistent with the actual express words used. The final point in that context relates to the termination point. And what I, with the greatest respect, would just invite you to read is Mr. Justice French's judgment. Can I just ask you to look, please, at page it should be page the references, that the passage that I wanted you to read sort of before the judgment, I know you've read it already, is Mr. Texera's witness statement from 26. Sorry, it's in the judgment. If we pick it up, please, at page 154 of the bundle, page 154.
Sorry, I've printed one off version of this, which is at 3206. Could we look at that?
Yes,
it's only because that's where all my my notes and annotations are. I'll just go to that, if I may.
Sure. So,
which paragraph of the judgment is the easiest way to get to it quickly?
Sorry. Yeah.
You stick with your reference if you want, but just
Okay,
give me the paragraph of the judgment.
So the judgment, so paragraph 26.
26, right.
But you need to read paragraph 26 through to the 36. So 26 to 36.
Right. And what is the point you wish to make?
Just once you've read those.
Oh, right. You want me to read them now? Just give me a sec. I have read them, but I'll refresh my memory. Yes.
So the point there is that a specific request was made by the client to the marketing provider in April 2023, requesting support to rebrand. But from April onwards, there was resistance to the concept of rebranding, to the point that in July, my client said, if you decide to violate the rebranding request, we'll have to freeze payments and refer the matter to our lawyers. Now, can you jump then, please, to paragraph 64 of the judgment.
Yes, I'm there.
And this is Mr. Justice French's summary of Mr. Fontmante's own evidence at paragraph 64. As to the alleged delay initiating the claim, he said the rebranding notice sent in April 2023 was the first time the claimant was informed of the intention. This prompted further discussions. As the final deadline of July 2023 approached, discussions came to an impasse. Mr. Mant said that he realized there was no possibility of compromise and that the defendant would press ahead with the rebranding. Then over the page, you'll see that that is what then triggered him to apply ex parte in secret for an urgent interim injunction. And my learned friend has tried to characterize this as simply him seeking to enforce his rights or clarification as to the meaning of the contract. What he doesn't address is that the contract had a built-in mechanism for good faith resolution through the protocol for resolving conflict. And as it happened, Mr. Fontmante was refusing to rebrand to the extent that he was applying to court for an injunction to restrain it from happening. But what the judge, Mr. Justice French, concluded, and you'll see this at paragraph 94. At paragraph 94, the very final sentence, having summarized why that thesis was nonsensical, he says, additionally, the defendant was entitled to call upon the corporation of the claimant in the implementation of a co-branding strategy. So where we were is we had wrongly been dragged into court. We had actually offered an undertaking simply as the price of an adjournment to slow down the rebranding, not just for 2 months, but from actually April 2023 to the end of September 2023, because we had a marketing service provider who refused to implement what we were entitled to ask them to implement. And so we then terminated, not before the judge published his judgment, but with the benefit of the judge's judgment, explaining that we were in the right and he was completely in the wrong. So with the greatest respect, I would invite you to look at the letter of termination and simply as a matter of common sense to come to the conclusion that the pleading on this issue, that we've unlawfully terminated the agreement and that our unlawful termination has been repudiatory, which then been accepted supposedly some 9 months to a year later in a particulars of claim, that is fanciful. It's divorced from reality. And as it happens, if you do read the correspondence, not for the purpose of contractual interpretation, but for the purpose of understanding the termination circumstances, you will see that Mr. Fontmante was complaining and seeking to negotiate a better terms for himself, being quite insulting in the process, even before he then starts alleging in his court proceedings dishonesty and fraud, without ever having raised those complaints with us first. And it is, in a sense, trite, and we've got some footnotes in our skeleton about this, that is classic repudiatory behavior. You can't have an agent who's meant to be promoting your brand going to court in a public forum accusing you of fraud. And that's the end of the relationship.
What if there was a fraud?
It actually doesn't affect the analysis at all. It doesn't affect the analysis at all.
One of the reasons in the letter of termination is, and a very substantial reason, and you've just repeated it there to the forefront of your submissions, that he's made a false allegation of fraud, and therefore the contract cannot continue between these parties in those circumstances, and you, the defendant, has a right to terminate. But if in fact there has been a massive fraud, that is the result of the defendant's own conduct. I'm not suggesting for a minute I'm anywhere close to so.
The thing is, I wouldn't want you to think that my passionate advocacy is prioritizing that as the reason for termination, because actually, if you see the sequence, the chronology, or the logical sequence of the letter, it's actually the rebranding failure to cooperate, which is the primary reason for terminating at this point in time, because we've had all this behavior that's got in the way of us implementing our rebranding, contrary to our own contractual rights. And that's in circumstances where you can see that this goes to the very root of what a marketing and branding consultant's meant to be doing for us.
Well, I have that point.
But when you analyze the lawfulness of termination, provided you have one good reason to terminate, it means it's a lawful termination. You can't have somebody turn around and say, well, you might have had some other reasons which are less good, so I shouldn't have been terminated. It's totally immaterial. Now, as it happens, I mean, the point about is it a proven allegation or not, or disproven, in the end, it was raised before the judge. It was irrelevant. It was never taken to the mediator through the proper course. And part of the complaint is not just it's an allegation of fraud, but that the allegation rides a coach and horses through the obligations of conflict resolution and confidentiality. And so whether or not that particular allegation were in the future something which had merit, there's been such a wholesale breakdown of the relations, we're entitled to terminate. And that, we respectfully suggest, comes out of the law, which has the termination provisions which we've looked at, Articles 86 and 88. Unless I can assist your lordship any further, recognising the time, essentially, I'm happy to answer any questions, but I think you have our headline points.
Well, I do, and I'm grateful to you both very much indeed for elucidating what is a difficult issue and case. I obviously now will take it all away and consider it, but you'll appreciate there's a lot to consider, and I want to give it full and proper consideration. I will give you my decision and reasons as soon as I possibly can. If I come to a clear decision in advance of being able to give reasons, I may simply make the order with reasons to follow. I'm just warning you that's a possibility, but I haven't decided anything, but that is a course that might arise. And the other thing I should say is that I may not, because of other existing commitments, be able to do this before the Christmas holidays. But I shall do my very best for you, especially having regard to the unfortunate delay which has arisen through nobody's fault. This is a matter that required the attention that you've both given it, and I'm grateful to you both for that. So thank you very much. We will conclude now, and you will hear from me as soon as I can possibly achieve it. Thank you once again for your assistance, gentlemen, and most importantly, I never forget, because I was once where you are, my thanks also to those behind you. I know how very hard all of them, solicitors and or junior counsel involved, will have worked to enable you both to present the case in the persuasive way that you both have. Thank you very much indeed to them all.
And my thanks to, and to the court staff as well for sitting late, and to you.
Good day to you all.
Thank you.